B, my lord.
B2. 2B.
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 Yes,
Right.
Lord, 33.
Just 1 minute. 1 minute. Let
Yes.
us get the cover. 33 2B the purpose of the It is post approval.
It is a post approval.
Post approval.
Post
You have taken a decision and there
then
is
we
some
approached-
dispute. There is some dispute
Dispute
pending
which was
between
pending.
the parties in other
Not related, but since they are concerned.
Involving.
Yes.
involving. Some sort of involvement is there.
Involvement is there.
Therefore, there is a mandatory requirement of approval of the tribunal before you finally terminate.
No, termination happens, but the approval is, if it is approved, then
No,
it takes back to
what is
that
the-
date.
Then what is the meaning of such termination? Has the man been terminated?
Yes, my lord.
He is not working.
No, no.
He is not paid thereafter.
No.
And
So,
then
my lord,
then tribunal here declines.
declines.
For the reason, even though it finds there was no lacuna in the disciplinary
Proceeding inquiry.
however,
The prima facie case has not been made out. The reason being,
and there is no dispute on the main issue.
no, main issue is the dispute is regarding the original dispute, which is there is a common dispute of
No, that's a different issue.
yes,
The intra-party dispute,
yes, ma'am.
here intra-party dispute, there is no 10 proceeding
No 10
or section 2 proceeding.
no, ma'am.
It's a straightway 32.
33 to be because the
33
management has to approach. Because this is a safeguard which
Yes,
is
then
for
it
the benefit of the
It has to be admitted. The Maharana, this has to be examined because this is a negative order. Tribunal has declined for the obvious purpose that yes, there is no material to support the termination.
termination.
Okay. Nonetheless, it has at the same time approved the disciplinary inquiry order.
My lord.
So this appears to be contradicting both.
Yes.
My lord, if I may submit, if your lordship permit.
No, it is only a final hearing. So we are admitting this matter. Please admit. Issue notice. Now notice Korigi since there is already appearance on behalf of the
On caveat and copy has been served.
yes,
also.
on behalf of the workman OP number
2.
OP number 2 through Sri LK Maharana Learned Advocate by way of caveat. Even though one copy has already been served, a further copy of brief by way of notice on such party be served and receipt of the same be filed. One extra copy be served on the State Council who will be representing the presiding officer Industrial Tribunal Raurkela. In this case, notice one set as above. There shall be stay of the impugned order. Annexed 2 in the meantime.
My lord, if I may submit.
For any conciliation.
My lord, in fact, 2009.
In the initial stage, there is no scope for conciliation.
no
It
scope
is
for
33
conciliation.
to be.
And also regarding, since this was an issue involving fake certificate or the claim of fake certificate, the conciliation cannot be there also.
Age 49. What is your
Be
age?
about, I think, 52
50,
as on
52.
date. 52, 50.
All right,
So
sir.
time,
My lord,
LCRB called for main case, right? Liberty with the councils. For the council for workmen to approach the assigned court for early hearing.
my lord, that so far as interim order is concerned, section 17B is to be complied with.
17B, no, 33 2B, there is no application of 17B.
No, my lord,
17B is only in case of our section 10 or section 2.
my lord, in fact, in our honorable court, in a similar matter, sale against sale.
No, come to the
My
provision.
lord, 17B.
Come to 17B.
My lord. My lord, where
Let
may
us read together. I have
My-
lost this scope, maybe many years, but I am sure
about
it is only when an award is blocked
My lord,
Award means award under section 10
10
or
two eight.
nowadays
Two
the
eight.
section 2 also.
Two,
no,
section,
in fact, if I may place that section for your lordship's convenience,
Yes,
17.
section 17B.
My lord, may I place?
Yes, 17B. Yes.
My lord, where in any case a labor court tribunal or national tribunal by its award directs reinstatement of any workman and the employee prefers any proceeding
Here
against,
there is a direction for reinstatement.
my lord, 33(2)(b) has been rejected.
So therefore there is no direction for
No,
reinstatement.
in fact, if your lordship sees, I may be permitted to submit, my lord. This particular dispute was before this honorable court and went to the honorable Supreme Court. The Supreme Court, honorable Supreme Court.
No,
has
that was regarding disciplinary
no,
inquiry.
my lord, 33(2)(b).
Yes,
my
I
lord.
have gone through that.
My lord, 33(2)(b) that Jaipur Jilla Parishad judgment was clear that once 33(2)(b) goes to the honorable the appellate court, which is in this case is the writ petition court.
Where is the decision?
Then, my lord,
Because there must be an order for reinstatement and attempted to be blocked by management.
I'll just please.
Of course, there is no impossibility of these judgments. Nowadays, there is no fundamentally clearing with the
no, my lord, in specific.
with the person dealing with the matters, and they have variety of orders. Therefore, it is now
Lord,
not
in a-
impossible.
My lord, in this tribunal, the Honorable Rourkela Tribunal had passed an order against SAIL RSP 33(2)(b). They have come before this honorable court in a writ petition. There, the honorable division bench had awarded that the interim order will.
be that sale.
Yeah, same.
What was the original order passed by sale, which for which they went to
Removal, my lord. Exactly,
removal?
identical. And the honorable court had, while
Removal order sought to be approved.
my lord,
Yes.
Removal order sought to be approved unless there is approval by tribunal or labor court, whichever court undertakes. It's a tribunal only.
Yes.
So unless it is approved, then the action
The
of the
finality will not. be-
management doesn't stand.
my lord, in that particular case, my lord, this honorable division bench,
Okay, let us see, this judgment is 2B also.
my lord, if your lordship turns to page 14, my lord. My lord, paragraph 14.
What was the issue there?
My lord, removal thereafter 33(2)(b) for seeking confirmation of that termination order.
Yes.
Paragraph 14, if your lordship say.
No, just 1 minute.
My lord,
Allowed or rejected? Who went to High Supreme Court?
my lord, if your lordship sees the first page, respondent was an employee of the appellant bank. He was dismissed from service after a domestic inquiry.
Come to the factual background in this case so that if it matches or not.
My lord,
Come to para 3.
My
Para 2, 3. Para 2 and 3, if your lordship would see, that would clarify the factual position also.
Yeah, or last para 1 first read.
my lord.
If the approval is not granted,
I'll place, my lord. If the approval is not granted under section 33(2)(b) of the Industrial Dispute Act, whether the order of dismissal becomes ineffective from the date it was passed or from the date of non-approval of the order of dismissal, and whether failure to make an application under section 33(2)(b) would not render the order of dismissal inoperative.
so that was the issue.
My lord, section.
So the issue you are raising is not the issue there. Therefore, any discussion doesn't bind us. Mr. Maharana,
My-
one issue may crop up. One issue may crop up.
My lord,
Approval is not yet made.
my lord.
Okay. Then for my opinion, and I hope my brother will agree with me,
My lord.
17B doesn't come.
My lord.
Ultimately, if they fail,
My lord.
then you will be entitled to entire salary
My lord.
with all benefits, but no 17B.
My lord, if I may only permitted to submit, my lord.
No, actually, where you find reference to 17B in this judgment?
No, my lord,
This was
paragraph.
not there,
No,
therefore there is no
My
question.
lord, I'll just cite
You are
paragraph
referring to 1-4,
1(4).
para 1-4.
Para 1(4). My lord, para
It
1
doesn't refer to 17. The problem is
Can't-
that it has to be answered
Can't
by the
refer because the question is something else in paragraph 1.
My lord, paragraph 14 says that once.
Your argument is well taken. Even Mr. Nanda will also understand what you are arguing.
My lord,
that once you are not removed, you are continuing in service, then what will follow? What fell from my lord?
Yeah.
You will get everything.
You will get everything.
I think he will not, I mean, he knows that. I mean, the employer is
And-
taking that risk.
And Mr. Maharana, the greater aspect is we are staying in the impugned order.
My lord,
So therefore, their approval comes to exist.
my lord,
Seeking approval comes to exist.
my lord.
So in the interregnum, there is no question of 17B. Please don't.
My lord, my
pursue.
only last submission, if your lordship.
Please don't.
My lord,
pursue.
in a similar
Please
case.
don't.
Find out a
pursue.
decision which at least
This-
refers to
this is the-
17.
This is the judgment, my lord. 17B. This is the judgment. which I'm-
17B vis-a-vis 33-2B.
My lord, 17B. My lord,
Vis-a-vis
17 yes, my lord.
33 to
Yes,
B.
my lord.
Then why are you not showing that judgment? Why are you
In fact,
taking us here and there? You must understand, Mr. Maharana.
My lord.
You must understand, I have a
Mr.
35
Maharana,
years
if
practice.
if they fail in their challenge,
My lord.
then 14 will follow.
My
They
lord,
know that.
I completely bounded, my lord. My
So-
only submission is, my lord.
No, you have to straight away come to 17.
My lord, my
Because you are
only-
not, you
my
see, you
lord-
are not approving this, their action now. You are
My
only
lord,
issued
It is
notice.
kept pending.
My lord,
Kept pending.
It
My
is
lord-
now kept
my
pending.
lord, only submission, if your lordship permits. Only submission. Last.
Please
submission.
don't waste time.
My lord, only submission.
No,
My
no.
lord, similar case, this honorable court in the case had passed an order that the.
No, I don't agree with such orders. I don't agree. You must appreciate me and Mr.
My lord,
Nanda.
my lord.
Both are having large practice in
Absolutely.
industrial dispute
I bow
side.
down, my lord. I
It
bow
is
down.
good. You are in industrial side, you will be
I bow
learning
down.
lot of things.
I bow down.
Therefore, please cooperate. Don't pursue. Yes, that's all.
My lord.
Item number 2.
Next.
Please, Lordship.
Item number 3.
My lord, here, the order passed under section 33C2 is under challenge by the state.
This is again 32.
No,
33
33C, no, 33C2. Initially, what was happened, Lord, the opposite part number 1,
Hmm.
Lord, who was disengaged from service. Part number 1, who was disengaged from service, my lord, he
Yes.
Lord, preferred industrial dispute, my lord. So the award has gone in his favor while directing for reinstatement in lieu of back wages, my lord. A sum of ₹5,000 was awarded. He was not satisfied, therefore he preferred a writ. State also preferred a writ.
Right, state lost.
State lost in its writ.
And the
So for the-
his
his
dispute was
Partly
allowed.
partly allowed, partly allowed.
With little modification.
Yes, and it has been caught.
5,000 compensation,
Yes,
it will
yes,
be
yes.
20,000
Yes,
compensation.
during pendency of both the writ petitions, my lord, what has happened? Well, he had filed a ID miss case that is under section 33C2.
That also complied.
That was complied by the government.
Complied. That
And
is for
he-
a previous
he-
period.
Yes, and he was reinstated.
Now it is for a subsequent
Subs-
period,
No, what has happened?
10 to 18.
Yes, 10 to 8. So
10 to 18.
Yes,
Which was never a dispute.
dispute before. So
Your
scope,
only plea,
yes,
your only plea, you have filed the counter affidavit, come to your counter
Yes.
affidavit. There,
Annex 4.
yes, page 35,
Yes,
para 3.
yes, ma'am.
Your only plea that he was not allowed to work.
Yes,
Where is that material?
No, my lord, my respectful submission is, my lord, before your lordship, is that there is no scope under section 33C2 to adjudicate upon this aspect that he has not been allowed to work. It should have been subject matter of a
No, you
dispute.
are arguing negative, Mr. Ghosh. To block 33 to
C2.
B,
No, it is 33C2.
to C, C2,
C2.
C2.
Aye.
It is computation of a admitted dues.
Yes, yes.
It is computation of a admitted dues.
dues.
So once there is computation of a admitted dues application
Aye.
and somebody goes there with an emphasis that yes, I am working, I have been illegally not paid. So a burden lies on you that there is no work with him. And to establish that burden, what you have discharged in your written statement or the counter there, only line, one line,
That he has not
petitioner has not been asked by OP management to perform his duty up to 24/4/18.
80.
And you fail to establish, you have not laid any evidence.
No, my lord, what has happened, my lord?
Of
In his
course,
application-
it has to be examined.
Yes.
We can't pass a judgment now.
No.
Notice. Issue notice and request. But you be prepared. I
Yes.
may be there, I may not be there.
No,
Be
no, I
prepared.
understand.
This will be hunting you again.
Yes, yes.
Because here,
Yes, particular admission.
you simply say that you are not allowed to
Hello.
work. You are simply saying you will not work.
Another aspect is, my lord, in 2010, so far the.
No, those are
complication-
irrelevant.
So that was compliant, and so far the writ petition is
Those are
concerned.
irrelevant. Rather, that establishes that there is no termination at any point of time. So therefore, you must have a valid termination to take away service of this man. And having lost in the earlier ID battle,
Yes.
ଆପଣ ହାରି ଯାଇଛନ୍ତି and 18 ରେ ହାରିଛନ୍ତି ଶୁଣନ୍ତୁ ଗୋଟେ ଜଜମେଣ୍ଟ ହେଲା 17 ରେ
ସେଟା ଆମ judgment ଟା ଯୋଉଥିରେ କି ଆମେ ହାରିଲୁ।
17 ଜଜମେଣ୍ଟ ହଉଛି the
Previous.
modification. Justice Parija and Justice
yes.
Mahapatra.
Aye.
Then the other judgment
judgment.
comes. Other judgment is dismissing your matter.
Yes,
So up to 17 at least,
at least. Yes.
there is nobody's case of termination.
Termination.
Even up to 18, when the matter was argued in High Court, nobody argues there is termination. And he claims from 10 to 18. Now suddenly you comes up in 2019 filing this one,
Right.
that he was not engaged. Have you ever taken this plea?
Yes, my lord. With much respect, my lord, we'll have to go
You
back.
should
to
have
that
at
again.
least-
Yes, award. The award which was, my lord, it commenced from 2005.
Mr. Ghosh, one must understand, once there is award in a section 10 proceeding, directing reinstatement with compensation so and so. So a person is reinstated after the modification order of the division bench in his favor.
Yes.
So he is reinstated. Then once he is reinstated, there must be a valid termination.
Yes.
Therefore, 33C2 has well adjudicated the matter. Be prepared. My brother judge may be there in due
Yes.
justice.
My lord, the law is law. We cannot go travel beyond the scope of law. But there are two interim applications. One is for dispensing with certified copies. The other one
Mr.
is.
Ghosh, if it is not a direction for regularization or anything, I think you should not have challenged this. Whatever he was a DLR or a daily, whatever NMR, you would have been
In fact,
considered as
he's
NMR.
he's been allowed to contest his conducting.
Finality of adjudication.
Instead of
Court has
challenging,
directed.
you could have called that poor man. You say this, take this much and sign. There is a mutual understanding. It would have been closed. And say the note to close it.
Had it been a private management procedure, this thing would have happened.
Oh,
These
Sir,
happen-
more
there
for
might be
you.
mistakes.
Mr.
More
Ghosh-
for you, it is difficult.
Mr.
Private is
Ghosh,
easier.
of course, those days have gone. Otherwise, there were days when state council simply stands, say, sir, don't record my submission, allow this. Those were the days. You have seen, I have seen. Therefore, don't be afraid of these officers.
No, I'm not. But fact is
No,
that.
maybe government.
Right?
Maybe government. Law is law. You are law officer, you have to assist the court. And what else we are doing? We are only giving justice. One side may lose, one side may win. Yes. Stay of the, stay se te refuse to kar diche, stay.
No, she is continuing, but payment part is concerned. They have calculated and said that you
Okay,
pay.
all right. There shall be stay of the impugned order, however,
Next week.
subject to payment of 40% at least, without prejudice to either side, claim of the either side. 40% ତାକୁ ଦେଇ ଦିଅନ୍ତୁ। Interest calculate କରିକିରି 40% of the amount along with interest awarded by the tribunal. ହେଲା? Which will however be without prejudice to claim of either side. Payment be made within 1 month of the order. Yes.
item number 3,
ନା ମାଟା
Lordship, the
ଏଇଠି
case
ସବୁ
may,
ଗିୟର ଚେଞ୍ଜ ହବ। ମାଟାକୁ ଯିବ ପୁଣି ଯିବ ଲେବର ଭିତରୁ ତାପରେ ଇଲେକ୍ଟ୍ରିକ କୁ ଯିବ। All right. Now Matta, yes.
Lordship, the case.
You are a
may-
wife, madam.
Lordship, case may be.
Your wife claimed 3 lakhs rupees per
Lordship,
month
permitted to
compensation.
withdraw, Lordship.
She has been awarded 1 lakh.
Lordship, kindly permitted to withdraw, Lordship.
Withdraw. Very good. Thank you. Good sense prevail. Because otherwise, what I was thinking, there's no discussion on even granting 1 lakh. Salary component has not been taken into account. She has claimed 3 lakhs, pay her 1 lakh. Council doesn't want to. Please file a memo. Want to press the writ application.
Oblige, Lordship.
Shall a memo be kept, memo filed to this extent, memo be kept on record and matter standing. Na lekho. Ye PP mante na. Okay, dismissed as not pressed. Aako totally solution.
item 4,
May I please the Lordship?
Not
When the present petitioner is challenging the present appellant is the husband.
Another matter. This is my husband.
Yes, ma'am.
Dismissed as withdrawn, memo be kept on record. ठीक है, please आपण माने निजे चिंता करंतु ହେଲା ଆମେ ଆଦେରେ କଣ ପ୍ରି litigation mediation ପୁଣି post litigation.
Five, I'm appearing through VC.
Yes, Mr. Misra.
Yes, my lord. My lord, this is a writ petition filed by the petitioner management challenging the order of the learned labor court. Grant
33C2.
lump sum amount of 1,50,000 in an application under 33C2. Now the labor, my lord, this pending, my lord,
Oh, please persuade your employer.
yes, my lord.
1,50,000 a workman.
My lord, he was working under the police
That's
department.
right. That's right. Maybe under what condition he could not work. That's a different thing.
He's
Of
not working.
course, we find there is no discussion on the amount fixing.
Yes,
Even then, 1,50,000 for a mighty
But
management
the issue is one of unjust enrichment, that's all.
and engaging counsel of your stature.
These are all,
Engaging counsel of your stature arguing from Delhi gives
Milord,
lot of
this is-
indications.
my lord, this is a Bhadra District Cooperative Milk Producers Union. Your lordship knows that this is not a rich organization. And apart from that, 1,50,000.
In any case, in the status of management,
My lord, your lordship will appreciate that he was working elsewhere in the police department that has been found by the labor court. But in spite of that, 1,50,000 has been.
admit ହେଲା ଏଗୁଡାକ ସବୁ ଯୋଉଟା ଆଇଡି କେସ୍ ହଉଛି ସବୁ admit ହବ admit issue notice call for LCR okay in ID case number so and so ବୋଲି ଲେଖୁଥିବ miss case ରେ notice as above requisites as undertaken by day after tomorrow ହେଲା miss case ରେ notice as above one set there shall be stay of the impugned order and so and so and so on. However, subject to a release of 50,000 in favor of the workman, OP number so and so. Workman OP number. Workman OP number
OP number 2, my lord.
3.
2.
2. OP number 2. At least within a period of 1 month. Payment under the interim direction shall however be without prejudice to subject to result and without prejudice to contention of either parties.
Lord, can I just state one thing that your lordships must direct that we will deposit that 50,000 in the registry of this honorable court.
No, no, let him get.
Lord,
Let him get.
this is complete unjust enrichment.
Poor man, poor man.
Lord, he was working during that time.
Consider, prevail upon, call that man, arrive at a conciliation at your end, close this issue. किसी टंका दे दी छाड़ दियो तो litigation सुनो तो ये सब litigation रे.
I understand. absolutely.
My worst experience. Management used to lose or management used to spend more than the amount involved. So who is in benefit? ଦେଇଦିଅନ୍ତୁ ମର୍ସି କରିଦିଅନ୍ତୁ ମୋର କାମ କରିଥିଲା କିଛି ଦିନ ହଁ କିଛି ତାର ପାଇବାର ଥିଲା ଦେଇ ନଥିଲି ଦେଇଦେଲି.
I agree with you. Absolutely.
Persuade your employer to have an amicable settlement in the meantime, file a memo, pay him, get an undertaking, file a memo. We have settled.
Very grateful. Very grateful.
Thank you. Next.
Item 6.
Another case of
Again,
33
33-2B.
33-2B, because my lord, the reason of this number of 33-2B applications, so far as sale is concerned, because your lordship knows that Coke Oven case was pending, where the entire involvement was about 6,800 employees. So anybody who is any decision is to be taken, these applications are filed. And here
Peculiarity is in both the stages, the workman did not appear. Is the workman
still, yes,
workman surviving?
he is surviving.
How could you know?
Lord, that was what but during the period when the matter was pending before the inquiry officer. But
That is right. He attended the conciliation. There is no dispute.
yes,
But thereafter, he is
He has-
absolutely all through, right from 2000.
right from
The second judgment comes in 22 also.
that also he was
Annexure
expired.
7.
And
Annexure
notice
6 is
paper
March and
publication,
Annexure 7
everything
July
was-
probably.
A notice was through paper publication, everything was done.
Right, notice that the Asila. But then how he will be served now?
Lord, we will try to find out. Your lordship will issue notice on whatever the present address is there. Otherwise, we'll try to find out if the whereabouts. We'll just, my lord, point out his permanent address.
Come
is
to
from
the cost title.
district court, cause title. The permanent address is Pradhanpada PO Bodadam,
District Cuttack.
Bodadamdorpur district. Cuttack.
District Cuttack.
Yes.
So you take out notice, also simultaneous notice on the paper publication
Yes, yes.
in both publications at Raulkela as well as
As
at
well as
Cuttack.
cut. We will do that.
Issue notice on the question of admission. In the reading of both the impugned orders, this court find the workman never appeared.
Undivided Cuttack district ki Bada Damodarpur kouthi hai? Kendrapada, Jagatsinghpur,
I'm not aware, my lord, of the.
Unless it is that Narsinghpur side, there is no such place. Address time भूल ହେଇଗଲା ତା ମାନେ ସେଟା ଯେତେବେଳେ ସେ ଚାକିରି କରୁଥିବ ସେତେବେଳେ ଥାଇପାରେ
Maybe.
ସେତେବେଳେ ସେ ଆଡ୍ରେସ ସେ ଦେଇଥିବ ତ ତେଣୁ the workman did not appear in the proceeding by both Annexure 6 as well as Annexure 7. In the circumstance, this court, while to avoid any delay on the notice aspect, this court while directing notice through court on the opposite party number 2, there should also be notice by way of paper publication on the opposite party number 2, both in a publication at his permanent address as well as a publication involving his service place. Yalla. The draft publication be provided. Requisites for normal notice be filed by day after tomorrow. By day after tomorrow, there should also be filing of draft paper publication before the registry
That
by
will
Monday?
get to,
By Monday?
By Monday.
by Monday. Both kar do by Monday. है ना? And registry directed to approve the draft publication by Wednesday. Let there be publication by next Monday. So bracket date rohibo. है ना? And 3 copies of such publication be filed in court by the porridge of Friday. है ना? Se date daba. Sabutire date rohibo bracket. Miss case re, as an interim, there shall be stay of the impugned order. Annexure 7 ultimately.
Annexure 7.
Annexure 7.
Your lordships were saying to my learned senior regarding that
Yes.
government should take steps. So the only problem now is the virtual
So
mode.
per notice on OP number 1, extra copy be served on.
No, at the stage of drafting also. You have to ask some very
Yes.
plain and simple questions, put it on record also.
It
That
should
these
be a-
questions, if they don't answer, then court will be asking these questions.
Otherwise,
But in fact, virtual mode we are also marking. It's not that that who are watching because it's available and also YouTube now. YouTube, you
Yes.
can go. Anyone can watch
Anyone
anywhere
can
in the
watch
world.
it.
So not enter into the
so
this
that,
format.
that becomes sometimes a little
Some evening,
circumspect.
some evening I search our court proceeding in the YouTube. I find 1,400 viewers. Our case number, total case number in DB probably 30 or 25
These all
something.
are hearing matters.
Hearing matters also, including hearing. So there may be both sides mixed together 50 clients. But viewers are 1,400. So many people sitting at home also watching court proceedings, how the courts are proceeding. Press people are also watching how the courts
Yes.
are proceeding. So it's a, now the big risk is coming.
It's an
We have to be
examination
careful.
every,
You have to be careful. Because we are all
examination every
responsible for
moment.
society. Ultimately.
Earlier it used to be
My pleasure. Well, in this case, yeah, but it's an
Yeah, there is a direction for reinstatement with back wages 50%.
my lord.
So if you issue notice, what is your ground to challenge?
My lord, actually, your lordship, my lord, page 15. The management, my lord, took part in the proceeding, my lord, but not contested, my lord.
Pardon?
Not contested, my lord, not,
Management did not contest.
no, my lord. According to my page 15 of the brief, my lord.
It's expiry order.
No, appear, my lord.
Appeared but subsequently
Not,
dropped.
my lord. Page
Even then 17B follows.
My lord, 17
Once we notice
My lord,
you from the cost title, but it shows that somebody is there.
no, yes, my
Party
lord.
KC Misra.
My lord, file his vocalatnama, but not contested the matter.
Where do you find that?
My lord, yes, page 15, my lord.
Page?
15, 15, my lord. In order 6, my lord, page 6 of the impung order.
Yes.
My lord, third line, my lord. Accordingly,
Yes, read.
my lord, accordingly, the management was afforded a chance to prove the charges against the second party before this tribunal, but neither it availed the opportunity nor taken any steps to establish the charge against the second party.
Okay, all right.
And apart from one commission, my lord,
Okay, then,
the second party is a conductor, my lord.
right.
My lord,
Yes.
my lord, conductor. He has all of 14 proceeding and found guilty.
No, are you arguing on merit?
ନା ସେଇ ଗୋଟେ one ସେଇଟା ଖାଲି ମୁଁ your lordships
It is expertise, no doubt.
yes madam
Therefore, once he appears, he may be getting some money.
madam
Cost daba deki remind kariba.
yes as your lordship
But in the meantime, you have to continue with 17B. We are staying an award.
I have not to
It is automatic. No, you can't merely file a writ application challenging an award unless you comply 17B. It is
yes my lord that
file or doesn't file.
another thing my lord caveat petition is there madam caveat petition is there
Caveat there, who is the counsel?
ସର୍ଭ କରିଛନ୍ତି
ସେଟା ମୁଁ
Caveat
ତାଙ୍କୁ
attach ହେଇନି ଏଠି।
ହେଇନି କିନ୍ତୁ caveat notice ଆମେ ପାଇଛୁ
ତାହେଲେ ତାଙ୍କୁ କପି ଦେଇ ଆଣିଲେନି?
ଆଜି ଫାର୍ଷ୍ଟ ଟାଇମ ଆସିଲା ଏଟା
କାଲିକି ଆଣିବା?
next week ଆସୁ next Monday I will try my best madam
caveat ରେ address ଦେଇନାହାନ୍ତି caveat ତ compulsory ନା address ଦେବାଟା last schedule ରେ
receive office ରେ ହେଇଛି ମୋ ପାଖକୁ ଚିଠିଟା
ସେମାନେ ଦେଇଥିବେ
ଆସିନି ମୋ ପାଖକୁ
But ଏଠି attach
caveat ର
କରିନାହାନ୍ତି।
address ଟା
In the course of hearing, the Tripathi learned counsel for the petitioner brings to the notice of the court that workman has already appeared by way of caveat. This court, however, doesn't find any caveat application attached to the writ petition. Direct listing of the matter on Monday along with caveat petition if any.
ନମ୍ବରଟା furnish
And
କରିପାରିବେ
indicating,
ଯୋଉଟା ସିଏ ରିସିଭ୍ କରିଛନ୍ତି
ନା।
ଅଫିସ ରେ
ସେ ନମ୍ବର ନାହିଁ ମୋ ପାଖରେ ପୁରା
indicating,
particular
kindly
also,
make that
ଆଜ୍ଞା
get that.
also indicating the name of counsel filed the caveat in the listing. କିଏ ଆପଣ caveat ରେ copy ପାଇଲେଣି?
ନାଇଁ
Caveat copy
caveat notice ଯାଇଛି ଆଜ୍ଞା ଅଫିସ କୁ
ଅଫିସ କୁ ଯାଇଥିଲା। ତାଙ୍କୁ ପଚାରିଲେନି କିଏ ଓକିଲ
ନା
ପଠେଇଛି?
ସେ ଛୁଟି ଥିଲା ମୁଁ ପାଇ
ତାହେଲେ ଆମେ ତା ନାଁଟା
ଆଜ୍ଞା
କହିପାରିଥାନ୍ତେ।
ମଣ୍ଡେ ଦିନ
ଏଇଠି କାଳେ ବସିଥିବେ ବି ଜାଣିପାରିଥାନ୍ତେ।
ଆଜ୍ଞା
All right. ଆସୁ Monday ଆସୁ get all these
All these,
informations.
madam.
Yes.
obliged
In the meantime, office is also directed to find out the caveat, if any, at the instance of the workman. Attempt to serve copy of such caveat on the on Sri Tripathi counsel for petitioner. And give a report on the same on the next listing.
Item number 8.
Item number 8, may I please, Your Lordship? Your Lordship, the petitioners union had filed two ID cases, which bearing number ID case number 3 of 2021 and ID case number.
That's right. It is pending.
Yes, Your Lordship.
You want targeting.
Your Lordship, a limited grievances to Your Lordship may.
What is the position of this dispute?
They haven't submitted any written statement or appearance.
Written statement already filed.
No, Your Lordship.
Written statement file ହେଇନି ଆମେ ID case ଟା କେବେ 29 of 22.
Yes, Your Lordship.
Written statement file ହଉ ତାପରେ ଆପଣ move କରିବେ.
Your Lordship, in annexation number 8, the Ministry of Labour had issued a order which clearly states, which had referred this matter to the Labour Court and directed.
It is already registered as ID case 29 of 22.
Yes, yes. Your
Therefore, what is the relevance in making reference or not? It's already registered. The dispute is registered. So
But the-
question is, unless written statement comes or the party is declared ex parte, it may not be desirable to target the proceeding. These are not simple proceedings. These are evidence related.
Yes, Your Lordship, but the order, in the order, it has been mentioned that the tribunal shall pass the order within 3 months, but they hadn't complied to that.
Submission. What you are referring to, be careful in your submission. So if there is a statute, then you have to straight away say that.
Otherwise,
Annex
reference
8
ହେଲା
page 36 ଦେଖନ୍ତୁ.
Yes, yes.
36 ରେ ଯୋଉ the said tribunal shall give its award within a period of 3 months. Under Secretary to Government of India.
Yes, sir.
Can the Under Secretary or the government say, let it's approval of the government, let us assume also, no procedural, can it be done?
And in most of the statutes also, there is prescription for closing
So,
proceeding
so
during.
statutory prescription,
It is
if any,
never
then you bring to the
possible.
notice of the court. That yes, there is a statutory prescription that is not being done. So then there is a, at least supervisory power we can exercise. And when we are saying that it's a matter of evidence, detailed proceeding is to be done.
How long you are in practice?
Lordship, 6 months.
6 months. A lot of things have to be learned. Okay, we don't blame you.
CGIT has functioned recently, in the month of November for last 1.5 years, they are defunct.
Right, all right. On his own submission of learned counsel for the petitioner, even though the dispute has been registered as ID case 29 of 22 on the file of Kapakhe register
CGIT.
CGIT, Bhubaneswar. No, but there has been no further development. Even there is no filing of written statement as of now. This court consider the grievance, take serious note of the grievance of the petitioner. And even though unable to target the disposal of the dispute at this stage, however, direct the CGIT to ensure filing of written statement. To ensure at least filing of written statement at least within a period of 3 months of the date of communication of order. Hala.
Much obliged.
So written statement also and shall also further take care in disposing the dispute. Hala. In accordance with law and giving fair opportunity to both sides as expeditiously as possible.
Obliged.
That is the best order you can get.
Obliged.
Item 9,
এটা কোন ହେଲା ବିଚିତ୍ର ହେଇଗଲା ଦେଖିପାରୁଛ ତ ଜବ ହଉଛି ବନ୍ଦ ହେଇଗଲା ବି ନା ଆମର ପୁରା କଟିଗଲା ପୁରା କଟିଗଲା okay ଦେଖିବା wherever both side counsels are there we can continue continue except visibility yes Mr. Das.
My lord, only sole prayer is to direction be given.
Okay, all right, 1:1 is pending.
Yes, my lord.
1:1 is pending, so we give a direction for taking early decision. It is before RLC.
RLC is Raulkela.
Raulkela.
Yes, ma'am.
Okay, consider the submission of Sri Das. Repetition involve the following innocuous prayer. Considering simple prayer for directing the RLC Raulkela OP number 1 for taking a lawful decision on the pending application by Dhanesha 1 at the earliest. The repetition stand disposed directing RLC's Central Raulkela OP number 1 to expedite the disposal of Dhanesha 1 lawfully, preferably at least within a period of 2 months, but however providing opportunity to party, if any, likely to be affected.
Then the petitioner has challenged the order passed by the Labour Court Jaipur under section 33C2 of ID Act. This is without jurisdiction, my lord.
Without jurisdiction?
Yes,
why?
my lord. My lord, law says that after retirement, he has no power to adjudicate a fresh dispute. The opposite party number 1 is a retired person. Highly.
Can he not claim his area?
Area claim before the registered cooperative society.
Why?
My lord, I have given a decision.
33C2 dekhela.
I have
33C2 is only computation of area admitted.
no, my lord. That is a execution proceeding. 33C2.
Yes, that's
execution
computation of admitted areas.
Now, who is the employee? No, not a retired.
Definitely with the employee, no allow kiye jibo 33C2.
He is a retired employee.
Maybe.
My lord, I have given decision of a division bench. Decision ta deuna tikke de.
Officer
Again, decision ta diyon. Decision ta diyon.
Item 10.
10 serial. Well, I have
C2 asandu.
my lord.
Ago 33C2 padandu. Where it restricts that no retired person can go.
My lord, 33.
33C2 padandu.
My lord. Where any workman is entitled to receive from the employer any money or any benefit which is capable of being computed to in term of money, and if any question arises as to the amount of money due or as the amount at which such benefits should be computed, then the question may subject to any rules.
Therefore, the period for which the claim is made, one must be an employee, a workman, and there must be a claim existing against an employer.
Yeah, my lord.
So the period of claim, whether he was a workman or not. What is the period of claim? Tell us.
Period of a claim, my lord, his arrear salary and
period of claim we say arrear salary.
No,
We don't say what are the components.
Period of claim of the salary. My lord, I am reading.
Sir, date. Kindly confirm.
Yes, sir.
Kindly refer to the date.
That my lord, to 22/7/2019 to 30th/6/2020.
Kodi paile seda. Ko page re
Page 15 of the
brief.
impound order.
15 page 15 of the brief. Na kono? Read petition.
Brief. The applicant Basanta Kumar Das has filed this application under section 33C2 of Industrial Dispute Act, praying to direct the opposite party, Koraput Central Cooperative Bank, to pay the retirement benefit arrear salary to the tune of 80,61,900.
Page match karuni.
Therefore,
Page 15 from 50.
Therefore, retirement dues,
Yes.
as well as arrear salary,
Yes.
while he was continuing as a workman,
My lord,
he might be retired in the meantime.
My
He is
lord-
not claiming post-retirement benefit.
my lord,
He
law
claims his
says,
retirement benefit.
my law
Mr.
says.
Sahu, you are referring to wrong dates.
Huh?
With greatest of respect, my
I
asked you
give-
specifically, the date is from 21/10/2011 to 1/3/2014, 31/3/14.
Admittedly, he was on
Paragraph 2. And
My-
he
my-
retires in 2014, that date.
Yes, my law already clear.
ପୁଣି ଆପଣ law କୁ
ଫେରେ ଆପଣ ତ ଗୋଟେ ଜିନିଷ କ୍ଲିୟର ହେଇନି ତାପରେ ଆପଣ କହୁଛନ୍ତି law is very clear.
Fact clear
Who is saying
କରନ୍ତୁ.
law is squared?
Fact clear କରନ୍ତୁ, when he got retired.
Retired 30th/6/2020.
36/6/2020.
6/2020.
So therefore, this period concerned when he was a workman.
31/3 years retired. 31/3/2014, not six.
Okay.
ଆପଣ
So that is-
retirement date ଟା ଭୁଲ କହୁଛନ୍ତି sir.
ନା ସାର୍ 30/6/2020 ପରା ସେ
31/3/14 ଲେଖିଛନ୍ତି ସିନୋପସିସ୍ ରେ ବାଇଧର ସାହେବ ଆପଣ ତ ନିଜେ ଲେଖିଛନ୍ତି ଆଉ ଦେଖୁନାହାନ୍ତି appendix 1 31/3/2014 On attaining age of superannuation.
ହେଲେ ବି ସେ 1-3 ଯାଏଁ ମାଗୁଛି.
appendix 1 ର
2011 ରୁ 31/3/2014
So when
exactly
he
that
was
period.
workman,
20 କୋଉଠୁ ଆଣିଲେ ଫେରେ?
ନାଇଁ ଏତେ ପୁରା ସାର୍ 5 serial number 5 appendix. The opposite party
if
number.
you argue, we dismiss. You argue, you are not making out a point.
No,
We dismiss.
my lord, he had a misappropriated 15 lakhs.
Forget that.
Yes.
Forget that.
Yes.
It's not a dispute, right? Under
Yes.
section 10.
Hmm.
It is only computation, admitted dues.
Yes.
You have already placed your card. You are having only ground in the repetition that he being retired 33C2 should not have been entertained. That is not sustainable.
My lord, workman definition ପଡୁଛି. workman definitely. Who is the workman?
आपण निज
Sir, you are
satisfaction
not-
ପାଇଁ ପଢନ୍ତୁ।
Sir, ये ଆପଣ ତ ଡେଟ୍ କୁ ଦେଖୁନାହାନ୍ତି ଆପଣ 20 କହୁଛନ୍ତି 14 କୁ
ନା,
ପିରିୟଡ ଟାକୁ କହୁଛନ୍ତି ପୋଷ୍ଟ ରିଟାୟରମେଣ୍ଟ ପିରିୟଡ ଇଜ ଫ୍ରମ ପ୍ରି ରିଟାୟରମେଣ୍ଟ
Period of claim is pre-retirement.
ହଁ, Lordship.
He was a workman undisputedly. ଆପଣ 1000 ଥର workman decision ପଢିଲେ ବି
ଆପଣ
prove
ସେ
କରିପାରିବେ।
ବ୍ରିଫ ସେୟା କରିଥିବେ ଆପଣ
ନାଇଁ,
ସେଇଟା ପ୍ରି ଅକୁପେସନ ଅଛି ଆପଣଙ୍କର ଯେ ସେଇଟା କହିଲେ ବଟ୍ ୟୁ ହାଭ ଟୁ ଚେକ୍ ଦ ଫ୍ୟାକ୍ଟସ ନା
ନା ସାର୍ ସେ 30/6/2020 ରେ ରିଟାୟାର୍ଡ କରିଛି ଆମର ପାରା 5 ରେ ମୁଁ ଲେଖିଛି appendix 1 ରେ ପାରା 5
ଟିକେ ଆପଣ ଦେଖନ୍ତୁ ଆପଣ ବ୍ରିଫ ସିନୋପସିସ୍ ଯୋଉଟା କରାହେଇଛି ବର୍ତ୍ତମାନ ଆପଣ ଦେଖନ୍ତୁ କଣ ଲେଖିଛନ୍ତି
ଡେଟ୍ ଚାର୍ଟର ମଧ୍ୟ ଲେଖିଛି ସାର୍ 30/6/2020 ଡେଟ୍ ଚାର୍ଟର ବି ଲେଖିଛି।
Just 1 minute. Is there ତାର claim (2014) and for an amount of with leave salary and retirement benefit also of the period when he was a workman. Yes, that is your sole ground. We reject the application.
My lord, already decided, law already settled.
What law settled?
My-
What law settled? What is this law? How to copy ଦିଅନ୍ତୁ।
ଦେଇଛି ଡବଲ କପି ଦେଇଥିଲେ।
Yeah, that's the settled law. We know.
Bo-
Undisputed claims cannot be computed.
Yes,
Undisputed. You are not arguing that.
yes.
which paragraph you are referring को paragraph कौन
It's a misnomer. It has no application to this case. This has no application to your case.
Fully applicable.
You are not arguing that point, Mr. Sahu.
Yes.
You are not arguing that point.
And my
Your argument is once he is retired,
no
33C2 should not be entertained.
no, my lord, 2 points. One of the retired person cannot claim under section 33C2 and also this is the procedure for execution of any award or any order passed earlier. 2 points I have
No,
taken.
not necessary. Not necessary. Admitted dues. Admitted dues can also be computed. Where have you disputed that these are not his
ଆପଣ
admitted dues?
undetermined plea ଟା କୋଉଠି ନେଇଛନ୍ତି straight away this with your experience you will realize where you have taken that plea that it is undetermined due and it has been
It's
determined
it's a disputed dues.
ଆପଣ ତ କହିଲେ ଯେ ସେ retire କରିପାରିବେନି
Again.
then you are saying that he has retired and is claiming for his period in service
Two
Now you are
points I have-
shifting. Now you are shifting. Come to your written statement. Let us see where have you taken that stand.
Written statement, my lord, annexure 3, page 34 and 35. Para 9. 35 re para 9 re lekhichi.
Yes.
It is most respectfully and humbly submitted that
Just
the
1 minute. 1 minute. What आपको written statement page?
ଆପଣ ତ କଣ audit report ଦେଖଉଛି annexure କୋଉଟା କେତେ annexure
annexure 3, page 34-35, page 35.
annexure 3
ଏଟା audit report
32 ରୁ
ଟା।
33 sir
ଭଗବାନ।
ଆପଣ ସବୁ ଆଜି କଣ ହେଇଛି କେଜାଣି ଆମର ଦେଖୁଛି 32-33 ସେଥିପାଇଁ ଆପଣ ପ୍ରଥମରୁ ମୁଁ ଆପଣ କହିଲେ ଆପଣ ପେଜ ମ୍ୟାଚ୍ କରୁନି କାଇଣ୍ଡଲି ଫାଇଲ ଦେଖନ୍ତୁ ଦେଖି କୁହନ୍ତୁ
ଆପଣଙ୍କ written statement annexure 3
annexure 3 ପେଜ 32
and page 32.
अच्छा भूल वाला ये
अच्छा କଥା
sir annexure 3 पेरुज annexure 3 next page my lord para 9 para 9 it is most respectfully and humbly
sir
submitted
ସେଟା ପଚାରାଇନି ଆପଣ ଫେରେ ଆପଣ
among
କଣ
stand in the
sir undetermined amount cannot be adjudicated court raises you very specific
Yes.
my lord has been very specific
yes
କୋଉଠି ସେଟା ଦେଖାନ୍ତୁ ଆପଣ ଲେଖିଛନ୍ତି undetermined ବୋଲି amount claimed by the workman is undetermined amount so it can't be determined in 33C2
And again,
ଆପଣ ପାଇଁ ଆର୍ଗୁମେଣ୍ଟ ବି ଆମକୁ ଫ୍ରେମ କରିବାକୁ ପଡିବ
ନାଇଁ
sir
ନାଇଁ
9 ବି ଦେଖାଅ ଥରେ।
ନାଇଁ para 9 ରେ ଲେଖିଛି
ପାରା 9 ତ ଆପଣ କହିଲେ ଆରମ୍ଭରେ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି ରିଟାୟାର୍ଡ ଏମ୍ପ୍ଲୟି କ୍ୟାନଟ୍ କ୍ଲେମ୍ ବଟ୍ ଆପଣ ସେ
ନାଇଁ,
ରିଟାୟାର୍ଡ सीए 11 मसिया रु 31/3/14 जाए क्लेम करचंती
Yes, yes.
आपण निजे लेखचंती
हाँ.
आपण कर देखंतु
हाँ.
you have signed that also
Yes,
he claims 2011 रु 31/3/2014
yeah,
so well within his period of engagement you are not disputing that even आपण जो 20 भी
हाँ.
कहचंती that is against you 20 नो ता रिटायरमेंट 14 आपण बहुत जगह लिखचंती आपण पारा 8 देखुना देखुन आपण सीज फ्रॉम 31/3/2014
सर ये अर्जन करो देखी देखी क्यों भूल भाल होची भूल भाल
याको कि आपण फाइल करथिले
हम फाइल
हां बढ़िया करछन बस ए दवा कथा क्लाइंट को
नहीं नहीं
20 रे रिटायर कला आपण लिखिले रिलेशनशिप ऑफ एम्प्लॉय एम्प्लॉयर सीज फ्रॉम 31/3/14 हैला 31/3/14 रे जदी आता डेट ऑफ रिटायरमेंट एक्चुअली केते कहले
That in the order sheet also reflected to be.
पीरियड जहा लिखुची से 21/10 रु 31/3/14 even assuming 31/3/14 is the date of retirement so every claim pertains to a period when he was a workman and in your para 8-9 you have never disputed such claim you only say because he is retired there is no relationship exist he has to go for adjudication so we reject on both grounds
अर्जन मैटर नेक्स्ट वीक
no आउ इटी कोन रिहर्सल हबो की इटी कोन रिहर्सल होची की एकरे रिटन स्टेटमेंट फाइल करी स्पॉइल कर देले केस टाकू दुरे आमे आर्गुमेंट रे पॉइंट रेज करूछु आपण यू गो ऑन शिफ्टिंग योर पॉइंट्स फ्रॉम पॉइंट्स
ना मान लो आई
now you sorry we are not convinced on both the grounds so we dismiss had submission of Sri by the SAHOO learned counsel appearing for the petitioner. So also Sri Sonak Mishra, learned counsel appearing for the learned presiding officer, Labor Court, Jaipur. The writ petition involves a challenge to the order of the presiding officer, Labor Court, Jaipur, in ID miss case number 5 of 20
my lord
by Danish 1.
my lord annex
Further
6
also claiming, please take your seat. Further also claiming dismissal of the ID case 5 of 2022. Both of you sit, take your seat. Background involving the case is opposite party number 2. These are legal heirs.
Yes,
2 to
Lordship,
2 to-
legal
2
heirs,
to
Your
4, 1 to 4 are legal
They are
heirs.
the legal heirs.
Okay, 1 to 4 being legal heirs. Approach the presiding officer, Labor Court, Jaipur, in the district of Hirapur under the provisions of Section 33C bracket 2C capital of the Industrial Dispute Act 1947. Claiming therein that the workman Bhagavan Tripathi had the undisputed dues, particularly retirement benefit and arrear withheld salary, along with interest to the tune of rupees 25,171,000. 25,171,000. Madhuri 00. Detailing in the claim petition, the LRs have claimed there has been withholding of arrear salary for the period 21/10/2021 to 2011 to 31/3/2014 for a sum of rupees 11,76,120. Further, withheld leave salary towards retirement benefit amount for rupees 3,40,080, along with interest at the rate 10% for an amount of rupees 9,93,971, subtotaling rupees 25,171. Giving the details of the claim, the 33C2 application being filed, being called upon by the Labor Court, the OP number 5. OP number 5, the management on its appearance filed its written statement by Annexure 3 disputing the claim. The claim of entitlements on account of the workman by the legal heirs of the workman as detailed in Annexure 3. Judgment of Labor Court, after providing opportunity to both the sides, passed an order on 27/10/2014, giving the direction as follows. Para 10 ro quote kariyo. 10 and 11, page 48 and 49. Yes. Pursuing its writ remedy, the management through Sri Vaidhar Sahu Learned Counsel, taking this court to the grounds in challenge of the order at Annexure 6, raised the following two grounds. One, the workman, having been retired since 31/3/2014, the relationship between the employer and employee having come to cease from the aforesaid date, no dispute under Section 33(c)(2) of the IT Act would have been entertained. The second leave of argument of the counsel for the management appears to be, for there is specifically in the paragraph 8 and 9 of the written statement, the entitlement gained by the legal heirs of the workman remain disputed, and in this circumstance, there is no availability of the there is no scope for considering the claim of the legal heirs of the workman under the provisions of the Section 33(c)(2) of the ID Act. Advancing his submission and in reference to the plea of the management in the written statement appearing here at Annexure 3, further also through the grounds raised in the writ application, to substantiate his submission, Sri Vaidhar Sahu Learned Counsel also took this court to a decision of this court in the case of Divisional Manager OFDC Limited Barikota versus Umamani Naik and others, decided on 1st September 2020, reported in 2020 bracket 2, volume 2, OLR 977, and taking this court to particularly the observation of the court in paragraph 14 therein, attempted to draw the decision to the support of the cited herein above to the support of the management. Considering the rival contentions, State Council in the defense of the impugned order involved herein, reading through the provision at section 33 C2 of the ID Act, attempted to take out the grounds on this regard at the instance of the management and contended there is clear application of the provision at section 33 C2. Further, State Council also asked, since the period of claim the period of claims, this gentleman reading the specific pleading of the parties. Okay, it also appears it is only on this plea. Both sides have submitted before the presiding officer labor court and the impugned order is an outcome of such process. Reading the specific plea and the material produced, This court find while the workman claim through the 33C2 application for the period area salary, area withheld area salary from 21/10/2011 to 31/3/14. And withheld leave salary towards literal benefit while he was continuing as workman. It is now considering the objection of the management before the competent authority and reading through paragraph 8 and 9 also taken care of by the presiding officer in his impugned order. This court find there is no denial to the fact that claim of the workman pertains to the aforesaid period with the specific plea by the management petitioner herein in paragraph 8 that the relationship between the workman and the employer came to be ceased from 31/3/2014 when the workman got superannuated. It is in the above. Okay, while keeping the above factual aspects in mind, this court now examine the provision at section 33C2 of the ID Act, which reads as follows. C2 33C ର head note ଟା ରହିବ. Okay. Recovery of money due from an employer ରହିବ. Then C ର ତମେ 2 କୁ ଚାଲି ଆସିବ straight way. Starts from where any ends exceeding 3 months. Okay. Reading the aforesaid legal provision, there should not be any doubt that the proceeding under section 33C2 undisputedly involves computation of entitlement from the employer of any money or any benefit which is capable of being computed in terms of money. The provision also enables the authority also to take up any question related to such aspects. Also to take into account the question, if any, relating to such subject. In the circumstance, this court find. In the circumstance and for there is no whisper of pleading on the disputed nature of claim, except specifically pleading. The proceeding was not entitled for the reason the workman was already retired by the time he puts up the 33C2 proceeding of filing the 33C2 proceeding. Like in the circumstance, this court find the grounds raised herein on the non-applicability of the provision at section 33C2 doesn't apply to the case of the workman. This court here again, at this stage, takes into account the decision cited at bar by the petitioner in his attempt to take out, petitioner management in his attempt to take out the applicability of the provision at section 33C2 of the ID Act through the citation divisional manager bracket supra. On perusal of the judgment, this court find the dispute therein involved if the competent authority If the competent authority for specific dispute raised by the management on the entitlement of the workman therein with clear specific plea disclosed in paragraph 3 of the judgment therein, the decision came to hold in the event there is dispute on the entitlement of the workman, then the competent authority lacks jurisdiction to decide such issues under the provisions of 33C2 of the ID Act, for it being a nature of execution dispute. The decision absolutely has no application to the case at hand. Coming to the second question raised by the management and has taken note herein above in paragraph so and so. This court here reading the plea of the stand of the management through para 8 and 9 taken note herein above finds there is no seizure of relationship between the employee and employer for the period of entitlement claimed remaining pre-superannuation. In this circumstance, there is also no substance. This could find no substance in the second limb of argument. Peruse the reasoning given by the presiding officer in the impugned order and finds, this court finds, there has been reasonable reasonings supported with law and the provision attracted herein, requiring no interference in such orders in exercise of power under Article 226 or 227 of the Constitution of India. Read petition the stand dismissed. In this circumstance, however, there is no order as to cost. Put a note of it out for it. The 33C2 proceeding was moved by the workman, died in the pendency of the proceeding, and proceeding was undertaken by the legal heirs, opposite party number 1 to 5.
Item 11,
ये जब रखी था Yes. Yes.
Here is a case, my lord. I am the noticee under annexure 10, where I have been called upon to implement section 3 of the IDA.
Your application for exemption under section 3 is pending before the competent authority.
Competent authority, you also may kindly see.
And
page
under
75.
11, there is a complaint for violation of section 3 as well as section 9.
There is no complaint. They have so much issued to all the general managers of the small collieries.
So therefore,
The Ministry
what is your submission?
My submission is
Annexure 11 will be dependent on a decision on annexure 10, or annexure 10 will be a decision dependent on the decision in annexure 11. Exemption must come first.
yes, exemption must come first, but
Yes,
the
what
colliery,
who is
Coal
there to
India is
oppose?
pressurizing the
RLC Central. Yes.
Yes,
Why are you not taking a decision on annexure 10?
Let me take instruction, my lord.
Huh?
Let me take instruction. Why? they are
You will
not
take
taking-
instruction.
Yes,
Page 75 will
All
also.
right, then we issue notice, no coercive action.
Yes.
In the meantime, why don't you file response to annexure 11?
Yes, I have already filed.
Oh, annexure 12 is already.
Yes,
there.
already
You-
filed, because there is an apprehension of criminal proceeding. That is why.
At the submission of Mr. Learned Counsel for the petitioner and Central Government Counsel for Nalek. In the course of hearing, Counsel for Central Government takes, seeks time to take instruction. Matter needs examination. Issue notice on the question of admission. Hello. 2 extra copies be served by your notice to OP numbers. OP number 1 and 2, 1, 2, 3, all.
Yes, Bill.
Yes, 1
Yes,
to 3.
for all this.
1, 2, 3, 3 extra copies. We served. In this case, in the meantime, notice as above, counter if any be filed within 4 weeks, within 4 weeks of service of copy. Okay, in this case, notice as above. Then in the pendency of the writ application, pendency of the writ application should not stand as a bar on the part of the opposite party. Number 2, who will take decision on annexure 10?
Annexure 10, my lord, the OP3 will take the decision.
OP3.
Yes,
OP3 may take a decision on the same. To doesn't stand as a bar in taking a decision on the same by OP number 3, but however providing opportunity to party likely to be affected. Okay. Further and communicate the decision thereof through affidavit to this court. This court further directs independence of the writ application since the matter is adjourned on the asking of the Central Council. There should not be any coercive action on the petitioner involving the so-called notice by annexure 11.
10 million. 10 is the notice. So-cause notice under annexure 10.
Annexure 10, sorry.
Yes.
So it is so-cause টা 10.
Okay.
So-cause লেখাটা 9.
11.
11.
Okay.
Okay, decision 11 kariye. Should not stand as a bar on taking a decision on annexure 11. উপরে রাখি দিয়েছি সেটা 10 বলে। ହେଲା? No coercive action on so-cause notice at annexure 10.
Item 12.
May I please your lordship?
Yes.
My lord, the
Mr.
simple
Patti.
grievance of the petitioner that my lord, he approached the OERC, my lord.
Annexure 1 is still pending.
Yes, my lord, till pending.
What is your avocation? You are MDP vision.
Yes, my lord, he is a franchise holder, my lord. He is a franchise holder for electricity collection of.
Right, of course, in your representation, you have raised so many
Yes, my
technical
lord.
issues.
Yes, my lord.
So many technical issues.
Yes, yes.
Is it required to be considered by the OERC or anybody else?
My lord,
Have the competency?
Yes, my lord, OERC has to consider, my lord.
कहाँ थी council OERC रा कहाँ थी? ना आजकल लोग क्या सुना थी? They have a standing counsel. All it and so one the lawful decision by nature. Maybe you will be required to make a fresh request.
Yes, my lord, that's,
Alessor one won't work now.
yes, my lord.
Se party nahi.
Did you get the question what fell from my lord? Because if it is not a electricity distribution company,
Yes,
then the OERC has no jurisdiction also.
so I'll to file a fresh application.
So withdraw
Our
this.
agreement
take
का सागर
application.
कहा हितला,
Withdraw this and
whom
take
you entered with the agreement, whether that the legal
For the
consequences.
timing, it is not maintainable.
Yes, my lord, because it is 2016, my lord.
Ah, right.
Still then, my lord,
You
7
should have
years.
applied your mind, Mr. Pati.
Withdraw to apply.
Withdraw petitioners memo de diyantu. Withdrawing with a liberty to approach competent authority in an appropriate application.
Oh, bless my lord.
Yes, item 13 orders kichi
For orders item 13,
orders.
But here is batch matter has been disposed of. Your lordship in accordance with the first judgment, dispose of this matter.
No,
But
what
the petitioner-
modification? Who has passed this order? Okay.
Your lordship has passed this order.
But senior judge is available, then why should it come to?
No, it's a division bench matter. Division bench matter. My lord.
Huh?
It's a division bench matter. my lord.
Division bench matter, you want modification of which bench order?
Your lordship bench. This bench.
28 order no, am order.
Again.
Am order कौन ହେଇଛି?
Here, my lord, your lordship can see the para one, this repetition.
ଆମ order ରେ କଣ modification ଚାହୁଛନ୍ତି?
Mr. Patnaik, kindly speak to the microphone. ଆପଣ
My lord, here para one, my lord, your lordship that Gram Panchayat driver, Kundali Gram Panchayat, Nuapada. It has to be modified. Here, my lord, they are working in, I have given the amendment, the schedule of.
He is not a pump operator come driver.
No, pump operator driver, but he is working in Saudi Gram Panchayat. What happens?
ପଞ୍ଚାୟତ ନାଁଟା କେମିତି
Oh.
ଆପଣ ଭୁଲ କଲେ ନା କୋର୍ଟ ର ଅର୍ଡର ରେ ଭୁଲ ହେଇଗଲା?
ସେଟା actually କଣ ହେଇଛି କୁଣ୍ଡଳୀ ଗ୍ରାମ ପଞ୍ଚାୟତ
ନାଇଁ ଆପଣ cost title ସବୁରେ କଣ କରିଛନ୍ତି?
ସେଟା କୁଣ୍ଡଳୀ ଗ୍ରାମ ପଞ୍ଚାୟତ ଅଛି
ହାଁ?
in the meantime
କୁନ୍ଦୁଲି ଅଛି।
କୁଣ୍ଡଳୀ ଅଛି
ଆଉ କେମିତି
କୁଣ୍ଡଳୀ
ଆଉ ତାହେଲେ କେମିତି ହବ?
in the meantime what happens କୁଣ୍ଡଳୀ ଗ୍ରାମ ପଞ୍ଚାୟତ has been bifurcated.
You should have pleaded that, you should have brought that amendment, at least you should have intimated at the time, then you file an application.
ଅଦର ସାଇଡ୍ କପି ସର୍ଭ କରିକି
Copy service କରି ଦିଅନ୍ତୁ, if they accept. Order benefits you. So effect of order, only difficulty is, or else we may say, since the Gram Panchayat is different, this order should not affect the prospect of benefit.
after bifurcation still
ସେଇଟା ଆମେ
will apply
ସେଠି-
mutual scrutiny.
ଆମେ ସେ ଆପଣ ଗୋଟେ application ଆଣନ୍ତୁ, it will be easier for us to pass.
କରେକ୍ସନ ତ ହେଇପାରିବନି ନା ଆପଣ factually it is correct ଆପଣ ଯୋଉଟା ପ୍ଲିଡ୍ କରିଛନ୍ତି ସେଇଟା ହିଁ ଲେଖା ହେଇଛି. That is the court's query.
Therefore, you bring an application for making necessary correction in the disposed of read petition.
That I have already filed and I
This is a read petition for,
that I
no, you seek modification, correction of our order. We have not committed any mistake. We have not committed any mistake. It is as per your pleading.
yes my lord.
Would you follow?
Yes my lord.
So ଆମେ ଏଟା ରଖୁଛୁ, ଆପଣ application ଆଣନ୍ତୁ, appropriate application, take the blame on you.
Yes.
Party did not
I understand.
intimate, Gram Panchayat name is changed in the
I
meantime,
understand.
benefit has been granted, so benefit should fall to the benefit of the client.
Okay, I am obliged my lord. So lordship call next week. but in
Day
the
after
meantime-
Monday ଆସିବ application. Monday, khare, we are simply adjourning to Monday.
Yes.
item 14,
14 my lord, I may permitted to file the second copy of the.
ଶୁଭୁନି?
I may permitted to file the second copy of the report.
Second
all
copy
the-
ଆମେ କାହିଁ 2 ବର୍ଷ ପରେ permission କରିବୁ?
Single judge ଭାବି file ହେଇଥିଲା ଭୁଲରେ।
Huh?
Single judge ଭାବି ଭୁଲରେ file କରିଦେଲେ।
No, Mr. Acharya, in ours you could have filed it today even.
Today I have.
ଧରିକି ହିଁ ବସିଛନ୍ତି, ଫାଇଲ କରିକି କହିଥାନ୍ତେ ଯେ ଆଜ୍ଞା ମୁଁ ଫାଇଲ କରି ସାରିଲିଣି. Why you wait for court's order? କୋର୍ଟ ଅପେକ୍ଷା କରିଛି ଯେ ଆପଣଙ୍କ ଦୟା ସେକେଣ୍ଡ କପି ଫାଇଲ କଲେ ଆମେ ଲିଷ୍ଟ କରିବୁ.
It is ready with me, just now I filed.
ତେଣୁ ଆମେ ଲିଷ୍ଟ କଲୁ, ଆପଣ ଦୟା କରିବେ କି ସେକେଣ୍ଡ କପି ଦବା ପାଇଁ? ଆପଣ ତାକୁ ପୁଣି ସାଙ୍ଗରେ ଧରିକି ବସିଛନ୍ତି. As undertaken, second copy be filed. And you are not a counsel even.
No, my junior, my lord, I may, my,
Where is your power?
my associate is there, Mr. Barik. my
Oh, then ଆପଣଙ୍କ କଥା ଆମେ କେମିତି ଶୁଣିବୁ? ଆପଣ power ନାହିଁ.
lord. My right.
ये power ଥିବା counsel କାହାନ୍ତି?
ଅଛନ୍ତି।
ତାଙ୍କୁ ଡାକନ୍ତୁ ଆଗକୁ। ଆପଣ ହଟି ଯାଆନ୍ତୁ। ପ୍ରକ୍ସି କାଉନସିଲ ସିନିୟର ଆଡଭୋକେଟ ହେଇପାରିବେ, ତାଙ୍କର ଦରକାର ନାହିଁ ପାୱାର। ତଥାପି ଆଜିକାଲି ହେଲାଣି ସେ ଦେବେ 6 ଟଙ୍କା 12 ଟଙ୍କା ସବୁ ଦେବେ। You are the counsel. Why did you not file second copy? It's a award matter. As undertaken. See, das kariba. To file the second copy of the brief in course of day. Failure of which the revision will be dismissed without further reference to bench. Ajim file kariye.
Alright.
Vasudev Barik. Already Vasudev Barik. Okay. Aji file karibe. Nale dismiss hejo.
Item 15.
My lords.
Yes, better withdraw and file appeal before the decision.
My lords, we have taken for steps for on behalf of Mr.
No.
My lords,
You are unnecessarily wasting your time.
my lords,
Your appeal lies to district judge.
my lords, if your my lords permits, Mr.
Pardon?
If your my lords permits, Mr. Pilot would address to
Tomorrow.
My lords, kindly,
Kotha hai jantu phone re.
my lords, kindly matter may be taken up on Monday.
Tomorrow.
All right.
Defect removal should have been removed today itself. Stamp reporting rightly suggested the appeal lies to the decisions. ता भी आपण कहबे पालित आसीबे आर्गुमेंट करिवे व्हाट इज दिस
My lords,
अनफॉर्चुनेट छाड़न
if your lordships
ठीक है
may
छाड़न दासु काली के आसु कथावार्ता हेकि आसंदु किछि इट्स नॉट अ कॉम्प्लिकेटेड इशू ओनली statute has to be gone into whether appeal lies to high court or to the district judge.
My lords, if your lordship permits, my lords, the appeal is maintainable under section.
Pardon?
My lords, the appeal is maintainable under section
Sorry.
19 of family code.
Next.
Item 16.
Maybe lordship. There is a delay of the question of limitations, your lordships. The
Defect काहे remove करनांती कौन what is the defect
petitioner-
defect कौन अछि 232 delays तो आईए फाइल ହେଇଛି
Yes.
4 टका 50 दबा कथा 2 टका देइछंती 2 टका 50 दउना
Today I file.
आजि देबे
Aye.
सर्टिफाइड कॉपी ऑफ इम्प्रूव्ड जजमेंट डिक्री फाइल हो जाइछ अच्छा ठीक तो
Aye.
ऑलराइट आजि फाइल करछंती
I file करी.
काई मेमो काई
कोई दिन
हां
sanction file करी लordship.
काई देखो नांती
कोई दिन
केते
केते टका थिला
धरि कि भी आसी परिबेनी कोर्ट को
केते टका से हितलाम जाननथि सिट पई ए करू 4 टका 50
अरे
file
सेटा हेइतले कोन हेइतांता कि डिले कंडोनेशन जेतु अछि हम आज नोटिस टा इश्यू कर देइतांतु अगेन इट विल बी लिस्टेड
in the meanwhile I'll file your lordship.
counsel for the petitioner undertakes to remove the defect 4A by filing memo meeting the deficit authenticated fee of rupees 2.50 2.50 in course of day. In the event such application is filed, such a memo is filed along with the deficit court fees shall be accepted, and office is directed to also accept notice requisites in the issuing of notice on the condonation delay application IA 190 of 23. This code makes it clear and notice accordingly. Makes it clear in the event there is no filing of deficit court fee, the matter will be dismissed without reference to further
Today
reference to.
I'll just now file.
हाँ हेला in course of day करछि परा एवडा को करिकरी आपण माने आसीबा कथा डिवीजन बेंच रे कोन ए सब सबमिशन हबो
जानि नथिल सर 4 टका 50
इवन सिंगल बेंच रे हाई कोर्ट रे भी सब आर्गुमेंट हबा कथा नो 17
Item 17.
Mayor, please, your lord. My lord, I have filed the second copy of the brief, my lord.
My lord, I may be pardoned, my lord. They have not served the copy upon us. We are for the OP number 1, man.
This one 17
My lord.
आपण appear करिवे का पई
OP number 1, my lord.
सेंट्रल गवर्नमेंट पे
My lord.
OP
Along with
number 1
learned DSA.
कॉपी दियंतु ताको कॉपी देई दियंतु
कॉपी आज दे दी
second copy filed in court copy on the central government council undertaken by tomorrow list this matter to Monday.
Day after
Monday and
interim order is in.
Monday.
Interim order is. All
admission पे आसियो मंडे
सेकंड कॉपी फाइल कले नी रिपिटिशन फाइल कले 12/6 रे कोर्ट रे फाइल करछुंदी इंटरिम ऑर्डर पे चले आसलेनी ना को
So I have substituted the petitioner, the legal I have substituted. It's the first time it is coming for admission. So
एडमिशन है नहीं
admission नहीं कि notice जाएगी.
notice जाइए notice जाइए
फाइनल डिस्पोजल मैटर
final disposal.
डिस्पोजल हमें टेक अप करि परिबनी खाली रिलीज कर दे सब्स्टिट्यूशन ता देखिला ऑर्डर हिची की सब्स्टिट्यूशन ऑर्डर ऑलरेडी देयर
Yes, yes, substitution already allowed.
के तारीख रे
ये last छुट्टी पर
1/5/2023.
केते तारीख कोन दो कंसोलिडेटेड फाइल
1/5/2023.
हां यस यस हां यस आई जस्ट डॉक्टर जस्टिस अलाउ कर दो आसियो देखिया खाली सिंपली एडजर्न करो
No interim order. Award is under challenge.
देखी दो तो सब तेरे देखी दो सब ताला हमें कोट मिस कर जाऊ तू रही जीवा काले इट शुड कंटिन्यू इफ वी एडजर्न यस
Item 19.
Item 19.
आधारे कोन किछि हल्का मैटर कोन अछि कोंतु
Award challenge is 13/3.
अवार्ड ऑफ द ट्रिब्यूनल
Industrial tribunal.
हां ताले हबनी by workmen
By workman.
then now judgment has to be passed देखियो एवडा नेक्स्ट वीक को रखो देखियो आगे तो
Milords, I appear for the respondent number 3, Milords, the opposite party number 3. And we are entering appearance for the first time, in fact, Milord, and we have filed our
invisible.
You are Mr. Sinha?
Yes, Milord.
No, we have a difficult, actually, our display is not working, so.
All right, it will come next week.
It will come next week.
Grateful, Milord. Same day, Milord?
Same day.
Wednesday?
Usually, if same day, if there are not too many matters, usually on the same day.
Next week को रखी दियो
Very good.
आपंगर भी next week आसुवा देखिवा जदी if we can reach by 11 o'clock.
Yes, Milord.
Then it may be a possibility. ताले हमें घंटा सुनलु गोटे केस हमें करिब आ 12:30 रे टेक अप करी कि घर को नबार प्रश्न नाही.
Milord, we'll take a chance, Milord. Not an issue. We'll take a chance.
Please, both side, wherever both side are ready for argument, please come with written note of submission as well as citations. That makes our task easy.
I am for item 18 that please go.
Milords, in item 19, Milords,
2 weeks after.
take the minutes of my last time.
1 month कर दियो सेटा तांकर 1 month कर
But for opposite party number 5, my appearance.
Upon the next week as well.
Item 23, my lords.
2020 के Mr. SAHOO.
It has already been paid, my lords. They are claiming wages for certain period from the contractor.
माइक रेज करूँ तो आपण कहीं नहीं जाऊँगी.
हाँ. So petitioner claims certain wages for certain period, my lords, from the contractor. I, being a principal, I already have paid it. So I have the document.
Already paid.
Yes, yes.
So don't press.
No, no.
Okay, he will not press.
No, my lord. Those periods he has not paid, contractor has paid, he is liable to pay, my lord.
Still some amount is lying.
Yes, my lord.
What
That
was
is
the
my-
direction? Let us see. Termination of service of Sri Ramchandra Behera is neither legal, page 9. Neither legal nor justified. The workman Sri Behra is entitled to
Well-
be reinstated in service with 50% back wages.
My lord, my matter 23, my lord.
23, my
23, my lords. This
Eta
document.
ଟିକେ ସାହୁଙ୍କର call
No,
ହେଲା ଆପଣ 23 କାହିଁ
No, we are going serially.
ପ୍ଲିଜ ବସନ୍ତୁ। ଆମେ ବିକେ ସାହୁ ବୋଲି ଡାକୁଛୁ ଆପଣ ସେଟା ଆଗକୁ କହୁଛୁ। Yes, Mr. Sahu, what is this?
These are expert award, my lord. Management didn't appear.
Expert award. What is the notice position? Where is Mr. Sudarshan Behra? କାହିଁ ଆସୁନାହାନ୍ତି?
Expert award dispute has been raised.
Expertise after valid service or not?
My lord, valid service. my lord.
So-
I have explained, my
So
lord.
then he has to be heard.
It has to be heard, my lord.
କୁଆଡେ ଗଲେ? ତାଙ୍କୁ ଆଣୁନାହାନ୍ତି, please inform Mr. Behra.
କାଲିକି ଆମେ ଆଣୁଛୁ ତାଙ୍କୁ ଧରିକି ଆସନ୍ତୁ ହେଲା କାହିଁକିନା ସେଠି ତ ଏକ୍ସପର୍ଟ ହେଇଛି ଆମେ ବି ଏଠି ଏକ୍ସପର୍ଟ କରିଦବା so let us avoid expert order add in part tomorrow.
Expert, management was set expert. I was expert.
Yes,
was
but
expecting-
now the other
What-
party is expertise.
You are
He is not there.
management ku management ta see proposition ta same na nahi.
On the basis of.
You have got
workmanship-
a expert award.
Yes.
Now you are seeking a expert judgment.
Yes.
Better to avoid. Tomorrow, wait for 24 hours
Yes.
or 20 hours. Say to
But
hide in part tomorrow.
23.
କାଲି ତାଙ୍କୁ ଧରିକି ଆସନ୍ତୁ
20 ଟା tomorrow.
hide in part କରିବେ।
Item 23 already have submitted document, man. Item 23, my lords.
23 ଆସୁଛି ଟିକେ
Item
ରୁହନ୍ତୁ
21.
20 ତ ସରିଲା 20 ସରିଲା ବସନ୍ତୁ take your seat.
21. My lordship is kindly taken on one time.
21 କଣ ଇଏ ମାଟା
But yes, madam.
ହଁ କଣ what has happened? This after notice matter. Both side ଅଛନ୍ତି
Your lordship, taking just to pass over, your lordship, can you take pass
ଆଉ
over?
ପାସ୍ ଓଭର ଆଜି କଣ ପାସ୍ ଓଭର ହବ ଆମର ତ ବେଞ୍ଚ ଏତିକି ବେଳ ଯାଏ tomorrow କରିଦେ
Tomorrow.
Madam, 1 week after.
କିଏ ଆପଣ କାହା ପାଇଁ କା ମିଷ୍ଟର ତ୍ରିପାଠୀ ପାଇଁ
No, appellant, Mr. Misra, your lordship.
ଅପୋଜିଟ ପାର୍ଟି
Yes.
ତୁମର on behalf of OP ବୋଲି କରିଦେ
Next week, yes.
Next week, yes, madam.
Next week, yes.
next week ତୁମର
Okay.
ତୁମର ରେଡି ହେଇକିରି ଆସନ୍ତୁ କଣ ମ୍ୟାଟ୍ରିମୋନିଆଲ ମ୍ୟାଟର କଣ ଟଙ୍କା ଦେଇଥିବ
ହଁ।
ଏ ଟଙ୍କା ଅଧିକା ହବ କି କମ ହବ ସେଟାରେ ପୁଣି yes
My lord, this is the.
yes what is the order
Order, my lord, this, in fact, I have filed a
Mike,
matter, my lord, for enhancement of the permanent.
your wife your wife
And the wife.
wife କେତେ 3 ଲକ୍ଷ both parties herein have settled the dispute between them and I have started residing together and there is no dispute between them for the present long since. With this specific averment there is also this application has been filed with joint affidavit as appearing at page 5, joint affidavit of both parties as appearing at page 5. To avoid any conflict, this court feels it appropriate to call both the parties for their personal appearance in court and to hear the actual position as on date from their mouth alone. In the process, this court fixed the matter to (27th of June). Let both the husband and wife herein appear in this court on at 10:30 on 27.
My lord. Obliged.
ତାଙ୍କୁ ଧରିକି ଆଣନ୍ତୁ କଳେ ବେଳେ କୌଶଳେ ତାଙ୍କୁ ଧରିକି ଆଣନ୍ତୁ ହେଲା ତାଙ୍କ ସାରା ଆଧାର ଆଣିବେ ଆଉ କାହାକୁ ଆଣି ଛିଡା କରିବେନି
Obliged.
yes 23
Item 23.
23 ସେ ତ dispute କରୁଛନ୍ତି dispute ଯଦି କରୁଛନ୍ତି you bring this on affidavit and serve him a copy because we can't pass order one-sided. Mr.
Lordship, may
Tripathi, learned
Your Lordship,
counsel
may kindly have a
actually
paragraph 14 of their writ application. Paragraph 14 of their writ application.
14 page,
Page 14, my lords.
page,
14 minor.
Page 14. 1-4, paragraph 1-4.
yes, in spite of
That in spite of repeated approach, when neither the opposite party number 6 nor the authorities of OIC with the principal employer did not pay the wages of the security guards for the period 1.
neither nor did not pay.
Yes.
Hmm.
From 1/12/16 to 38.
कौन हैला ताले neither nor ହେଇକିରି ଯଦି did not ହେଲା ताले कौन हैला
So, and the period that
नहीं
dispute.
रुहतु ताको pleading परा
आगे.
ଯଦି neither nor ହେଇକିରି did not pay ହେଲା ताले कौन हैला pay ही जाइछि ना नहीं कौन पेमेंट ही जाइछि
ना
अब आपण लिखछन नीचे हमें कौन करू
ग्रामेटिकल मिस्टेक
अरे neither
हमारा ग्रामेटिकल मिस्टेक
फाइल करू तो एफिडेविट से ताकर इंस्ट्रक्शन नियंतु हमें एटा तो एंड करि परिबुनी इन दिस प्रोसेस हला
only 8
in the
months
course of hearing Sri
मतलब 8 month claims only
Huh?
8 months claims only 8 months claim not
अरे अब से कहउछनी हमें देई देइछु आपण इंस्ट्रक्शन नै छन कि नै हमें जानिनु
ना नहीं चाहिए
आपण नै छन
आगे
ताले से एफिडेविट फाइल करदु ताको हमें कॉग्निजेंस को नबो हो कोन
आगे आगे
स्वयं आपण 21 रे फाइल करथिले से माने पेमेंट कले
28
12 माने डिसेंबर लास्ट डिसेंबर रे almost filed. Maybe your efforts have paid off also. You should be satisfied that by filing such petition, you have achieved the result.
We close the dispute recording his submission, but keeping it open in the event there is no final payment, you may reopen.
day after tomorrow रखी था day after tomorrow था
All right, day after.
हां
but instruction नहीं परिवे तो चिट्ठीटा दोछन
आगे हां चिट्ठा मते कॉपीटा खाली दे दियो मु दे दोती
Otherwise it will be unnecessary litigation. सेठी बसिगिरी नै गला टंका एठी आपण कहबे नै आज्ञा दिया हेइनी
हम परदिन कहि देबे
सीबी आसीबे नै आपण बाबू
नहले मु नॉट प्लेस कर
हाले क्लोज कर दबा
हां बस
हला
प्रॉब्लम
see Swai, this matter is and stand adjourned to day after tomorrow on the request of Sri Swai, who wants to take instruction on the claim of Sri Tripathi that in the meantime there has been payment of the arrears. Hala. Okay, place the matter day after tomorrow. Yes, sir. Mr. Acharya, कौन है मैटर
नोटिस जाइतला नोटिस ता कोन सफिशिएंट नै हम आउट दबो
आता रखी दे
सेदा रेकॉर्डेड है
लगे दी दीटा ब्रीफ दीटा कॉपी लगे हां कॉपी एस्टैब्लिशिंग कॉपी अटेम्प्टेड टू एस्टैब्लिश पेमेंट filed in court be kept on record. এটা কোন অ্যাডমিট হেইনি
নোটিস যাইতলা কিন্তু নোটিস এ অ্যাপিয়ার করনাতি আউথর জীব নোটিসটা
अदर साइड अपियर करना थी
না নোটিস যাইছি তা করনা
ना इशू नोटिस तो ही जी अदर साइड का नोटिस कौन हला
ओडिशा स्टेट फाइनेंशियल कॉर्पोरेशन पाइथिले निश्चित ना आसना लेवल डेट
fixing 19/5 for appearance. Neither AD nor on sub notice. Declined to appear. How to अपेक्षा करिबा the notice was already issued by order of this court dated to the opposite party one by order of this court dated 5/4/23. Office note discloses notice has been issued to OP1 fixing date of appearance to 19/5/23. Further office note disclosed neither AD nor unsubs notice returned from OP1. Okay, for there is nobody appearing for OP1, this court adjourned the matter for 15 days, at least to accommodate, give a possible charge to the opposite party number 1 to have his contest in the matter. Let's the matter 15 days after a date kar dabo Wednesday padu wala. That's all.
May I be pardoned, my lord? My lords, item 15, your lordship is adjourned for tomorrow. My lords, an IA has been filed. My lords, that IA may kindly called up.
कौन आपण एटा फोन रे कथा ही परिबेनी
My lords,
आपण बारंबार हमको डिस्टर्ब करछोनी नाही वेडनेसडे नुह फ्राइडे नुह मंडे आसु व्हाट इज दिस
my lords, the matter may kindly be called up tomorrow. My lords, and
Tomorrow?
yes, my lords, an IA has been filed. My lords, that IA may kindly be called up, tagged up with the matter.
You want tomorrow?
My lords.
All right, tomorrow.
My lords,
IA may be called.
Along with IA number?
200 of 2023.
200. 2023.
लिखी दिया.
Obliged, my lord.
Yes. All right.
IA
convert कर This court, while setting aside both the orders of the notifications at Annexure 1 and 2, issues a writ of mandamus against the competent authority, restoring the position of the petitioner as a notary forthwith. This order is, however, provided the period for grant of license is not expired in the meantime. In the event the license period has expired, there may not be any obstruction in the renewal of the license of the petitioner, for it was revoked illegally. This court also clarifies here that the judgment of this court shall not stand on the way of the complainant, Sonia Behera, OP number 3, herein for her pursuing other remedies available through any other statutory forum or legal forum, and the documents involved herein by Annexure 8 and 9 shall be considered in such forum in its appropriate spirit. WPC 10,000 of 19 does succeed. No order as to cost. As a consequence of this judgment, in setting aside the impugned orders Annexure 1 and 2 herein, there is no further order necessary for involvement of the petitioner's representation in WPC number 17987 of 2022, which is also disposed accordingly. Yes.
Fresh admission item number 2.
Item number 2, Lordship, the petitioner is seeking a direction to the Tehsildar for receiving rent in favor of the case land. Lordship, the case land was settled in favor of the petitioner's father through lease case number 365 of 1969. Thereafter, the rent schedule was issued in his favor. However, no rent.
Why he is declining?
He's declining. He started declining. He stopped taking rent since 2012. Thereafter, Sukinda Tehsil has been bifurcated to Vyasanagar. Thereafter, in 2020, we filed before the RTI. We seek information regarding such refusal.
You are paying the land revenue till 2012.
Since 2012, they have stopped receiving rent.
You are paying previous to that.
Previous to that, we have paid.
Where is the receipt?
Rent receipt is at annexure. It is attached to. It is at page 27. Page 27, 26. 26, 27.
You are Subhash Chandra Das. Who is this Bhattakrishna Das?
Bhattakrishna Das is my father. Deceased father. Thereafter.
So why are you not receiving it? Receive it without prejudice. Right. This is a
revision कौन है इतना OEA revision. Page 34 your lordship में kindly fill. Your lordship may not hear.
Lordship, I'm not a party in that OEA revision. Neither my suit.
No, I am observing without if there is no lawful impediment. If this comes on the way, then you may not be. What is this page 34? Is it involving same land?
Lordship, it's the adjacent land to me.
Adjacent
land, and no, I'm
may
not the
be,
party
may
to
not
the.
be. All right. Revision involve the following prayer through page 27. Document at page 27. Ms. Das Leonard counsel appearing for the petitioner contents, even though father of the petitioner was going on paying land revenue and the revenue authority was also receiving, there has been illegal refusal of receiving land revenue involving the disputed land involved within. Ms. Das Leonard counsel makes a specific plea that there is no lawful obstruction in denying the deposit of the land revenue from the petitioner, the legal heir of the original owner. The State Council bringing to the notice of the document at page 34 submits there might be lawful obstruction in the receiving of the land revenue. considering rival contention of the parties, this court, after recording the submission of Ms. Dash, that the order in page, at page 34 onwards has nothing to do with the case at hand. This court in the disposal of the writ application observes, in the event there is no lawful provision in the receiving of the land revenue involving the disputed land involved within, there should not be denial of deposit of the same. Tahsildar, OP number? Tahsildar, the OP number 3 is directed to consider the request of the petitioner by the requisition involved within and attempt to receive the land revenue provided there is no lawful obstruction in the receiving of the same by undertaking such exercise within a period of 1 month from the date of communication of order along with copy of the requisition.
May I make an additional praise?
Free copy of the order be handed over to State Council. Yes.
Lordship, the current HAL ROR has been recorded in favor of my father. Lordship, I may pray before your Lordship to record it in my favor since my father
Record you have to apply.
I'll apply.
You have to apply.
I'll do that.
There is no High Court writ of mandamus.
I'll do that.
Item number 3.
Find out provisions from OSS Act or mutation area.
Mutation.
May I please, Your Lordship, may I be permitted to place this matter on behalf of
Pardon?
Mr. May I be permitted to place this matter on behalf of Mr. Ramdas Acharya?
Kain, Chotonga Kain. Your name is not there.
No, Your Lordship.
Then you are not a designated counsel. Tomorrow the client may come and say that I had not authorized such a counsel to argue and she got a rejection order.
Your Lordship.
Eligible for magistrate. You should know once there is a power filed.
Your Lordship.
Counsel in the power file should come.
Pardon, Your Lordship. Next time it won't be.
So last chance, hereafter you will not commit this mistake.
Your Lordship.
Okay. It's
Your
a
Lordship.
loss to state revenue. And tomorrow the client may allege if you lose. If you win, it is all right.
Your Lordship.
All right. What is the case?
Your Lordship, here the representation wide Annexer 4 is pending before opposite party number 3. So, Your Lordship, here in the year 1988, Baleswar municipality introduced this site and service scheme under EWS category. So here both the petitioners approached the municipality and plot number 36 and 37 got allotted to both the petitioners.
Which opposite party is to consider?
That is the executive officer, Baleswar municipality.
Opposite party number?
Opposite party number 3, Your Lordship.
3.
Yes.
All right, let him take a decision. At the requisition involved the following there. Undisputedly request on behalf of petitioner. Inocus at this point of time. In the disposal of writ application, this court directed the OP number 3 to give a lawful disposal to Annexer 4 by completing its exercise within a period of 2 months from the date of communication of order along with copy of the. Yes.
Item 4.
Obliged, Your Lordship.
May I please, Your Lordship? I am challenging the order of the Honorable Lokayuk by Annexure 2, Your Lordship.
Please be on mic.
I am challenging the order of Honorable Lokayuk, which by Annexure 2, basing upon the order and the documents file, opposite party number 6 has been impersonating himself as the son of the petitioner.
Right. What recommendation made against you?
Your Lordship, page number 22, paragraph number 4, Your Lordship. May I permitted to read, Your Lordship?
Yes.
The allegation of the complainant is that Revenue Inspector Sri Bhimacharan Purti has intentionally submitted false and fabricated reports before the Tahsildar Puri in mutation case number, who acting upon these reports prepared incorrect ROR, Shri Bhimacharan Purti in his inquiry report dated 26/9/2013 relating to mutation case number 2631 of 2013 has mentioned one Haramani Pradhan as alive. I am not concerned with this person, though she had actually died on 28/2012. Similarly, in another case, he has reported Malati Pradhan as dead while she is actually alive. Yet in another
How that comes within the purview of Lokayuta, he rightly rejected. You may have a complaint that one record of right is allowed recording something and one record of right is rejected recording another thing on the availability of a person.
Your Lordship.
So you may go challenge that order.
Your Lordship, that order is under challenge.
So
before
you
this honorable-
challenge that order if you
But
succeed in
Lordship,
it.
basing upon this order, he's
No, this is in official functioning. Some information comes in and he gives a input. That doesn't mean that he intentionally works.
Then basing upon this order, he is using applying legal hire certificate.
Then go challenge that order.
Maybe liberty given to appear before the local learned Lokayuk. To challenge this order, liberty may be given to appear before learned
Lokayut has already dropped these proceedings.
No, it has passed in favor of the complainant.
Who are you?
I am not in the party of the proceeding, Your Lordship. I am no more concerned in this. I am not in power.
This proceeding already comes to close.
Your Lordship.
See page 23 with the above observation direction, the complaint is finally disposed.
Your Lordship.
So where you will appear?
I have to file intervener to appear.
Sorry. This is a post proceeding.
Because basing upon
Find
this,
out other options available.
basing upon this option, he is appearing.
On the complaint that the officer concerned is giving different informations in different proceedings on the existence of a person. Proceeding under the provisions of the Lokayuta Act was entertained and got to be disposed by the impugned order. Considering the submission of learned counsel and looking to the findings and observations of the Lokayuta, this court find there has been clear indication of petitioner having alternate attempts or alternate remedies. On his own submission of the learned counsel for petitioner, he is already pursuing the other remedies available. In this view of the matter, this court find there is no merit in entertaining the writ application involving a challenge to the order at Annexure 2, which is rejected hereby.
Deeply obliged.
The rejection of the writ application shall not stand or constitute to be an order negativing the petitioner's remedy or approach pending before any other authority.
So on humble, let this order of Lokayuk shouldn't be affect any other proceeding. It should be independent.
I've already indicated
You are
that.
deeply oppressed. Deeply oppressed.
Next.
Item 5.
May I please, Your Lordship?
Yes.
The petitioner is seeking to challenge the impugned order by by
15B proceeding, I am not entertaining counsel. Go for civil suit.
My lord.
Go for civil suit if you are affected by 15B order. I am not entertaining 15B orders.
My lord,
I have rejected so many writ applications on this ground. If there is a dispute, let it be resolved through civil proceeding. Not in a 15B where the authority works as a super tahsildar.
liberty may be granted to.
Petitioner wants to withdraw the writ application in order to pursue his remedy under civil forum involving the dispute involving Annexure 1. The writ petition permitted to be withdrawn, however, with liberty.
Item 6.
May I please your lordship? The petitioners are landless person, my lord.
He made an application for Vasundhara scheme to settle 1 quintal land.
କାଇଁ ବସୁନ୍ଧରା ଆପ୍ଲାଏ କଲେ ଆପଣ ଯଦି ଲ୍ୟାଣ୍ଡଲେସ୍ ପ୍ରଧାନମନ୍ତ୍ରୀଙ୍କର ଗୃହ ବଣ୍ଟନରେ କହିଲେନି
ନାଇଁ ମୋର ଘର ଜାଗା ନାହିଁ
ହଁ
କିନ୍ତୁ ଘରଟା କାହା ଉପରେ କରିବି
ଘରଟା
କାହା ଉପରେ କରିବି ସେଥିପାଇଁ କି ତହସିଲଦାରଙ୍କୁ ଦରଖାସ୍ତ ଦେଲି ଯେ ବସୁନ୍ଧରା ସ୍କିମ ରେ ମତେ ଗୁଣ୍ଠେ ଜାଗା ଦିଆଯାଉ।
ଏ ଘର ବଣ୍ଟନଟା କଣ ଟଙ୍କା ଦିଆ ହଉଛି?
ନାଇଁ ନାଇଁ ମୋର
ନାଇଁ, ନାଇଁ, ଏବେ
ପ୍ରେୟର
ଯୋଉ ପ୍ରଧାନମନ୍ତ୍ରୀ ଆବାସରେ
ହଁ
ସେଟା ଟଙ୍କା ଦିଆ ହଉଛି ଘର ତିଆରି କରିବା ପାଇଁ।
ଘର ଟଙ୍କା ଦିଆଯାଉଛି
ଓ ଆପଣଙ୍କ ଜାଗା ନାହିଁ
ନା
ଆଉ ଜାଗା ନାହିଁ ଯଦି ଯାଉନାହାନ୍ତି ଏଥିରେ ଆପଣଙ୍କର ଓପିଏଲ ରେ ସେଟଲମେଣ୍ଟ ପାଇଁ।
ବସୁନ୍ଧରା ସ୍କିମ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଗୋଟେ ଇଣ୍ଟ୍ରୋଡକ୍ସନ କରିଛନ୍ତି 2015 ରୁ।
ଏ ଚିଠି ପତ୍ରରେ କଣ ହବ?
ନା ଅନେକ ଲୋକଙ୍କର ହେଲାଣି।
ବସୁନ୍ଧରା ଇଜ ଏ ସ୍କିମ୍
Yes, my lord.
against
Unnecessary 3 your lordship may refer.
requisition involve following prayer. Finding petitioners request on the self-same issue by done. So one is pending.
Before OP number 5.
Before P5.
5.
Before dispose the writ application.
Keeping in view of unnecessary
OP
3.
number 5. To give a lawful disposal to the application at annexure 1 by taking decision within a period of 2 months from the date of communication of order, along with the copy of petition by the petitioner. କଣ କହୁଥିଲେ?
Circular is at unnecessary 3. Your lordship may say keeping in.
While also keeping in view the circular at unnecessary 3.
My lord.
ଆପଣ ତାପରେ ଲାଇନ ଲାଗିବ ଏଭଳି କେସ୍।
Seven my lord save.
ହଁ ଲାଗିଲା ଆଉ ତାପରେ ଚାଲିବ ଟ୍ରକ୍ ଟେ ଫାଇଲ ହବ
ଆଉ ଅଛି 10ଟା 12ଟା ଫାଇଲ କରିଦେଲି 2ଟା ଆସିଲା ଆଉ 10ଟା ଆସିପାରିନି।
ଦେଇ ଦିଅନ୍ତୁ 7ଟା ଦେଇ ଦିଅନ୍ତୁ କାଲି ଆଣି ସାରି ଦିଅନ୍ତୁ।
ଆଜ୍ଞା।
Item 8.
On behalf of Mr. kindly taken up next week, my lord. His father has been expired last week. On behalf of Mr. Bahadur. Kindly taken
କଣ
up
ହେଲା?
next week. His father has been expired last
has
week.
been expired.
Has expired. Has expired. Sorry.
all right କେବେ କରିବା ତାହେଲେ ଛୁଟି
Next week.
ପରେ କରିବା?
Next week.
ଛୁଟି ପରେ କରିବା ନା ଆପଣ ପ୍ରସ୍ତୁତ ହେଇ କରିବେ ପରଦିନ?
Sombar, Monday.
କଣ ମ୍ୟାଟର ରିପିଟିସନ ଦିଟା ଜଜମେଣ୍ଟ ଡିକ୍ରି ଅଛି କେବେ ମଲେ?
Last week, Friday.
Place this matter on 10th of July. July 10 ରେ ଆସିବ। Keeping in view there is bereavement in the family of the council.
Item 9.
Item 9, my lord, it is inaction of OP3 Tahsildar for not correcting ROR in my favor, my lord. Though mutation is allowed in 2016.
Your application for correction is pending.
Pending, my lord, since 2016. Though the order
What is
passed.
the proceeding number?
Proceeding.
That is annexure 3.
Annexure 3, my lord.
3.
3.
Okay, petitioner through the writ application alleges the proceeding for correction of record of right by annexure 3 is pending since 2015. Considering there is much delay in disposal of such matters, this court in disposal of writ application direct OP number
3, my lord.
3
Yes.
to conclude the proceeding. किसी case number काहे याद है?
Number achi, my lord. It is.
Hmm.
By mutation case number
Case
3884
number
of 2015. Sir, hazy achi mutation case number 3884 of 2015.
3884 टा सही proceeding.
Again, I understood 3 जोटा अच्छा हमारा.
Annexure 3 ର top ରେ କିଛି ଲେଖା ହେଇନି। ଏଠି all right ଦାଖଲ ଖାରଜ ମାମଲା 3881/2015. At least within a period of 2 months from the date of communication, but however, providing opportunity to party likely to be affected.
Obliged.
Yes.
Item 10.
Right, please, my lord.
Yes, Mr. Das.
All these cases are from Patia.
Pardon?
From the area Patia. And their land was mutated with the status of Patadar. That is under annexure 1. But thereafter, they made an application for conversion of the Kisama and conversion of Sattva.
That was also allowed.
No, that application, your lordship knows that online application was made. Then without giving them any opportunity on the basis of the RI report, Simply it was held that because it is a leasehold land, it cannot be done. But if your lordship will kindly turn to page 39, I will take your lordship to page 39. That is a part of a government letter.
All right, you take notice, sub copy, let them take this.
My lord, oblige, my lord.
So notice on the question of admission, I'll have three extra copies be served on state council, who is directed to take instruction. Okay. Place this matter 2 weeks after the date here.
Under the same heading. Under the same heading, let it come. We have small matter.
Yes, देखो जदि थारे म्यूटेशन ही सारिची आ लीज जदि सेलिएबल राइट थिबो काई ऑब्स्ट्रक्शन कर
आगे
99 इयर्स लीज हेले बिक्री करि पे नाइ जदि पटा 10 वर्ष देइचंदी लेखिथिबे 10 वर्ष परे से बिक्री करि परिबे ताले राइट
हेरिटेबल और ट्रांसफरेबल हेरिटेबल एंड ट्रांसफरेबल
हां आपनकर अधिकारीकर भूल द्वारा उकिल लाभवान होउछंदी इनवाइटेबल but why should we be loaded with such type of litigation, and that too Mr. Das like counsel in such cases.
Item 11. May I please, Your Lordship?
Yes.
My lord, the impugned order is annexure 9 series, page number starting from page number 56, my lord. The petitioner applied for third party transfer of his allotted plot, which was allotted under discretionary quota, that is single allotment plot, my lord.
Reject
Reject.
All right, take notice then. You should notice on the question of admission since the Mahapatra has
similar case got a same issue.
Similar case list out of date my lord, similar matter was listed to another date. My learned senior is telling that I have to take instruction regarding that. That matter is
I am issuing notice. You receive copy.
Yes, ma'am.
On the other case being listed, you argue that it may be covered by then. Okay. Mahapatra has the instruction to appear for the Water Development Authority, OP number so many numbers of copies of brief we served on Mahapatra by as undertaken.
I have already served 2 copies, my lord.
2 copies
tomorrow.
2 copies
already
solved.
solved.
Already solved.
Okay, I stated 2 copies of the brief already submitted on Mahapatra. Place this matter 4 weeks after. Instruction oblique counter, if any, which is made available by next day.
That matter is adjourned to next week, my lord. Counter file.
ଯଦି next week ସେଟା allow ହେଇଯିବ, then you may make a mention.
1 week after.
You may make a mention. ସବୁ case ରଖିବ. Covered ହେଇଗଲେ ମୁଁ ତ 1 month କହୁଛି. I will be there. Don't worry. Yes, next.
Item 12.
Development Authority ର ସବୁ area cover ହେଇ ସାରିଲାଣି. ଆଉ କୋଉଟା ଅଛି ଗୋଟେ ଗୋଟେ ଦେଖିବା ତାକୁ
legal ରୁ କେବଳ transfer କରିହବ
ଦେଖିବା. You also take instructions. Suppose third party is illegally rejected, then revive your order on your own.
I will.
Don't wait for court's order.
Item 12.
Satyanarayana Mahapatra.
He said no, it is not his case. He was asked by Mr. Jetty. He said no, it is not my case. Somebody else who is.
Then there is another Satyanarayana Mahapatra or Satyanarayana Mishra se. SN Mahapatra B se likhi janti. Rest is directed to indicate the name of the council properly by indicating SN Mahapatra bracket B. In the next listing of the matter, list this matter day after tomorrow.
Item 13.
May I please, Your Lordship? This is a petition, my lord. Petitioner challenges the inaction of the opposite party number 2 and 3, the Revenue Authority. The annexure 4 is the appeal oblique grievance petition before the opposite party number 2 is pending, my lord. Till 11/9/2018.
Appeal.
Grievance application of the petitioner is pending before the opposite party number 2.
Following prayer. From the submission of respective council, it appears petitioner has a grievance application by Danish for pending for consideration of collector of the district magistrate Jharsuguda in such event since 2018. ନାଇଁ ଆଉ ତାକୁ କାହିଁ ପର୍ସୁ କରୁଛନ୍ତି 18 ଏଇଟା
ଆଉ ଗୋଟେ ଫ୍ରେଶ ଟା କରିଦେଲେ ବେଟର।
ମିଳିବ ନ ମିଳିବ
ଫ୍ରେଶ ଆଉ ଗୋଟେ କରିଦେଲେ ବେଟର।
considering the scale representation involved herein. Observes in the event cause of action still surveys, it may be open to the petitioner to make a fresh application to the collector OP number so and so within at least 2 weeks' time. In such event, the such application shall be given lawful outcome, working it out within a period of 2 months from the date of communication of all, along with filing of the fresh application.
Item 14. In this case, my lord, the petitioner challenges the inaction of the Officer Sambalpur without giving any notice to the opposite party, petitioner's father, my lord. He has proceeded with the consultation case and pass orders, and his valuable land has been
Who are
added.
these opposite parties?
Opposite parties who are the beneficiary and the choco holders, my lord. And they are the.
Who are you?
I am the son of the petitioner, son of the opposite party number in the revision case, my lord. Where I have stated in Annexure 8, my father died on 19/5/2005.
You
But
are
the
one of the co-personer.
co-personal, my lord. My valuable land has been granted in.
Other family members are there.
Yes, other family members are there, my lord.
Okay, then is there any final outcome?
Final outcome, my lord, the revisional authority pass orders to correct the chocos in favor of the petitioners, my lord.
Annexure 9 is final order.
Final order, and the remand, they have remanded the case to the Tahsildar to conduct an field inquiry.
Remand is only for correction.
Yes, my lord. And the Tahsildar, without giving opportunity, my lord, by the time the petitioner's father had died, but showing him as sufficient notice, he has passed the orders, my lord. I have annexed the petitioners. If your lordships go to the page number 42 of the order.
Where are certified copies?
I have filed, my lord.
None of the impugned order, there is certified copy. None of the impugned order, there is certified copy. It's
Last
only all Xerox copy.
annex, sorry, ଓକାଲତନାମା ପଛପଟକୁ ମୁଁ annex କରିକି ଦେଇଥିଲି ସେଠି ଅଛି କି ଦେଖନ୍ତୁ କାରଣ ଜେରକ୍ସ ଗୁଡାକ ଲଗେଇକି
ଓକାଲତନାମା ପଛରେ କେବଳ ମିସକେସ୍ ଅଛି କି ପାଖରେ ଦେଖନ୍ତୁ ନଟ୍ ଫାଇଲ୍ଡ ରେ ରହିଛି ଆଣନ୍ତୁ ଶୁକ୍ରବାର ନେବି ଅଛି କି ପାଖରେ ଅଛି
ମୁଁ ଆଉ ସବୁ ଜାଗା ଆରେଞ୍ଜ କରି ଦେଇଦେବି
this matter next Friday ଦେଖନ୍ତୁ ମୁଁ I have already verified. I don't find any certificate copy. This is Xerox and that is also Xerox.
Self same issue out of read pending ଅଛି already your lordship has issued notice.
Then exemption ହେଇଥାନ୍ତା.
ହଁ ଏଠି certificate.
If these orders are already available in another read, exemption application should have been there. ନାହିଁ ଯଦି କେମିତି କରିବି ଆସୁ ଆଉ ଗୋଟେ ରିଟ୍ ପେଣ୍ଡିଂ ଅଛି
ଆଉ ଗୋଟେ ମୋରି ରିଟ୍ ଟା ପେଣ୍ଡିଂ ଅଛି 25,329 ଯୋଉଟାରେ ଆପଣ ଦେଇଛନ୍ତି ଷ୍ଟାଟସ୍ କୋ ଅର୍ଡର ଟା ବି ଅଛି ଆଜ୍ଞା
ତାହେଲେ ତା ସାଙ୍ଗରେ ପରଦିନ ଆସୁ
ତା ସାଙ୍ଗରେ ଆସୁ
these are the certified copy. In the meantime you prepare a miscase for exemption or else you may bring the certified copies of both orders.
Dispensing.
Sorry.
Yes.
Item 15.
In the meantime, steps as appropriate in the filing of the certified copies of the impugned orders be taken.
I may please. Well, settlement revision petition is pending for fresh start.
Settlement revision petition pending ଅଛି 15B କାହା ପାଖରେ pending ଅଛି
Opposite party number 2, that is
2
commission.
Okay. Petitioner alleges revision petition annexure to SRP 511 of 2021 is pending before OP number 2 long change This court from the perusal of the documents find that in fact the revision is pending since 21. In the event, so what is the position on notice of the notice on the respondents?
It is pending for fresh
admission है ही नहीं.
Fresh admission, okay, all right, fresh admission record किया ना. All right, 1 week.
item 20. I did.
20 also same. All right, 20. Yes.
Item 16.
1/6.
Well, I'm challenging the annexure 6 under multiple allotment by order dated 24/12/2000.
Prayer annexure 6 कथा लिखु ना दिखाएंगे खाली लिखी देले order dated so and so by so and so. Annexure 6 बोल लिखिबे नहीं.
Again.
लिखचंदी
नहीं मैडम.
नहीं. इटा टास्क फोर्स ऑर्डर.
Again.
केतोटी घर रखछंदी भुवनेश्वर रे?
गोटे घर अछि.
दीटा?
नहीं गोटे घर अछि. In the main माने beginning रू गोटे घर transfer ही अछि. And moreover the under annexure 4 the it was not within the municipality area in the beginning. By annexure 4 it was included.
आपनकर आउट घर अछि.
गोटे घर ही my lord अछि.
आ ये गोटे होछि 830 आउट होछि K/4.
My lord.
आपन स्त्री दीटा घर रखछंदी.
My lord, let's say kindly have a glance to paragraph number 7 of my read person, page number 5.
No, you must have been given so cause opportunity.
Yes, my lord, I have given.
So where do you find that reading in the so cause observation? You can't develop the case here.
No, my lord. In page number 12, running page number 12,
12 yes.
annexure 2,
Yes.
I have categorically stated that.
Which para?
Paragraph number 3. The paragraph starts from the house. The house allotted to me was in the revenue village Subudipur, which was not included in BMC area at that time. It was included BMC as per the Odisha Gazette notification 2nd May 2013, and the copy of notification is attached. I have also attached the Gazette notification.
Second house kebe asila?
Second house my lord
10 रे.
2010 transfer भी है.
Already issue notice है ना. Copy भी सावधान से महापत्र. Usually appears for development of cities. In the meantime, petitioner as well as opposite parties are all are directed to maintain status quo in respect of the disputed property. Yes.
Item 17.
Deep leverage.
May I please come up? Item 17, my lord, the case is covered by the decision of your lordship, the case of Dr. Saraswati Mahapatra.
Mike raise.
Yes, madam. The case is covered by the decision of your
Yes,
lordship.
what do you say?
My lord, they have filed one representation before the authority, my lord. My lord, that representation may be.
So that will be considered taking into account annexure 5.
Yes.
Annexure
Actually, my
5,
lord, the fact is that day before yesterday we received the copy. I have not also taken the instruction regarding that. If my lord.
You have preferred appeal.
No, my lord, we have not taken instruction regarding this, my lord, this file, because we have received the copy day before yesterday only.
So last Monday asu instruction.
Monday also instruction नहीं आई थी
Copy देइछंदी.
copy
Okay. There is already service of copy on council Sri Anand Mahapatra.
A letter longer date may be given.
For the development authority. Sri Roy, council appearing for the petitioner claims 6. Benefit, decision in favor of the petitioner in terms of judgment at annexure 5. Council for the development authority 6 time to take instruction and go through the judgment if it is. To find if it is covering the case of the petitioner. Place the matter on next Tuesday, on Tuesday. Yes. Nice.
Item 18.
May I please, your lords? My lord, the application under section 8A of the Law Act has been allowed and I have paid the conversion charges for change of a classification and the lease deed was also executed, but the corrected ROR has not yet been issued.
Okay, petitioner through the writ application alleges, even though his application for conversion has been allowed and amount being received, statutory dues being received, consequential lease deed is already created, but there is no correction of the record of right. This court in the disposal of writ application observed in the event there is no legal impediment By way of stay of such developments by higher forum, there should not be any obstruction in the preparation of the record of right. Dependent on above, the record of right may be corrected, provided to the petitioner by undertaking such exercise within a period of 1.5 months from the date of communication of number.
Next item, my lord, same. Next item, similar. my lord.
Next also same. All right.
Public.
Item 21.
After passing the final order by the Lawrence Civil Court, Civil Judge Senior Division, the petitioner submitted the same before the Lawrence Tahsildar for mutation. But the Lawrence Tahsildar not accept my mutation application.
Not accepting?
Accept it. Only behave that it is a court case. I am not entertaining this.
Take instruction. Why is not accepting? Now direction Devi is to pass, come to page 14.
Annexure,
If it is executable, find out.
yes, Annexure 4 is the application.
No, Annexure 4 may be application, but look to Annexure 1.
And this the court's.
It's a decree.
Yes.
Okay, decree to what extent? Suit be and the same is decreed preliminarily on contest against the defendants as per amicable agreement made between the parties, and the settlement petition along with case map be made part of decree. So there is nothing to be executed.
Yes.
Annexure 4 is the
mutation application, my lord.
So where is your pleading? He is not accepting this.
Accepting, my lord. Para Para 8, my lord. Para 8, my lord.
Page କହିବେ ହେଲା. Yes, ପଢନ୍ତୁ.
That the opposite one to have power to.
All right. At the submission of the respective counsels, take into consideration the plea raised herein and the plea taken in the course of hearing. Further, on the perusal of the copy of judgment and decree filed by petitioner by Annexure 1 and 2 respectively, this court find there is already a decree by way of settlement between the parties. Filing the read petition, it is alleged Tahsildar on an application for correction of record of right by Annexure 4 being filed, Tahsildar declines to entertain the application. There is specific plea on such allegation in para 8 of the writ application, considering serious plea and allegation against the Tahsildar, OP number
2, my lord.
This writ petition stand disposed directing OP number 2 to accept the copy application for settlement of the land dependent on a judgment and decree in the civil code. If it is submitted from the petitioner, if it is submitted at least within a period of 7 days, 7 working days.
My lord.
7 working days, and we will lawful disposal of the petition.
Obliged.
Item 22.
May I please the lordships. My lord, my case is covered by my lord's decision at page 107, annexure 13, where relying upon that Narottam Rathod decision, a settlement matter in respect of Sampur Mojam.
All right, yes, you want to examine?
Yes. Division bench judgment.
Say, my lord.
Division bench judgment.
Division bench judgment, Justice.
Yes, ma'am. Lordship
Then
decision.
my order, why are you not giving my order?
Yeah, I have annexed your lordship's decision at page 107, annexure 13.
107.
Page 107, annexure 13 is lordship's decision. Item
23 କରୁଛନ୍ତି. 22 ସରିନି.
22.
Item 22 is called. Here ଅଛନ୍ତି 22 ରେ ଆସନ୍ତୁ. Take रहंतु आपन next case.
Sorry.
Hello, this is target matter, my lord. The
All
case
right,
is pending.
revision case pending since
Yes, my-
2011.
Yes, my lord.
All right, targeted. Pending कहउछन आपण
तहसीलदार already remanding ହେଇଯାଇଛି କିନ୍ତୁ 2013
remand करछन्ती.
आज्ञा.
Okay, case 14 remand order.
Yes, ma'am.
All right, it is alleged on the original proceeding being remanded to the Tahsildar by virtue of judgment in the revenue case 25 of 11 by Danesha 1. Remand order though passed in 2012. The Tahsildar OP number
2.
Is not undertaking the exercise under section 11 of the Act. Considering the serious allegation, this court observed in the event, direction of the revisional authority by Danesha 1 is not given effect as of now, and considerable time is lost in the meantime. The Tahsildar is to do well in giving a lawful outcome to the remand proceeding pursuant to order at Danesha 1 by completing such exercise in the involvement of the parties likely to be affected at least within a period of 3 months from the date of communication of order. Pre-copy of order to State Council.
Item 23.
May I please?
My order is available at page
At page 107, my lord, annexure 13. Only in
107.
place of opposite part number 3 in paragraph 3, it will be opposite part number 2.
Okay, 107.
107 annexure 13. And it is also in respect of same khata, same plot.
Okay, এটা কোন হবে আনেশ 5 রইব
খালি 3 number paragraph রে opposite part number 3 জায়গায় 2 হবো এসো rental colony
রিট পিটিশন সেম রইব
yes madam
এই ওপি নম্বর 3 জায়গায়
3 জায়গায় 2 হবো WPC numberটা presently ইয়ে হবো same খালি ଅଛି সেই খাতা সেই plot हो
তো তার জাজমেন্ট ডেট ইস্যু বি হবে না
আজ্ঞা আজ্ঞা
ହେଲା এটা কভার্ড কেস 107 but देखियो नहीं से WPC नंबर काई बदलिबा हमें तो तार एनालॉजी टा फॉलो करूचे
आज्ञा आज्ञा नहीं WPC number same रहइबो 1608 same
बदलिबो ऊपर WPC नंबर
Yes,
बदलिबो
ma'am.
पार्टी ना बदलिबो
yes madam
एटी डेट बदलिबो हैला एटा रहिबो ई गोटा 3 जगह 2 हो
and my case is I have challenged both the orders order passed by the assistant settlement officer as well as the appellate authority additional sub collector come assistant
pardon I could not follow
my case is here the order I am relying upon that is the impugned order was only that of the order passed by the assistant settlement officer. My case is I have challenged both the orders ASO order as well as the appellate authority order.
Well, as well as appellate authority. नहीं हमें remit the matter back to ASO करिजे
आज्ञा
शेयर रहइबो काई
that will suffice yes ma'am that will suffice.
all right
Item 24.
Obliged.
just 1 minute it is made clear so in a paragraph 4 end re lekhibo the in view of the aforesaid direction this court set aside the orders
Under annexure 9 and annexure 11.
Annexure 9 and 11 lekhiwa na che puni confuse kari
Obliged.
Item 24.
May I please? In this case, my lord, the representation under annexure 1, page 11.
yes annexure 1 prayer court kar dobo annexure 1 since pending before collector Patak Upina so and so who is directed to give a lawful disposal within 2 months from the date of communication of order as well as read. Please copy of order to stay.
Item 20.
Your Honor, the revision case is
Fresh
pending,
admission.
not
Fresh
not yet
admission.
admitted, my.
Not admitted.
No, my.
Fresh admission. Right. Okay. Next case kono?
Item 26.
My lord, item 26, representation dated to 17/12/2022 is pending under annexure 4. And
Kono representation is?
My lord, to change the place of the government construction work to other page of Gochar land, Khata number 108.
Same order, Mr. 4 by Collector Balangir Opinabo Sancho. This was the direction.
Item 27.
Annexure 3 is the recommendation that 25, 24 by 23 regarding implementation of Vasudha Yojana for the petitioners Mauja. Co-Maujas are already implemented the Vasudha Yojana by the state government project.
Vote they not be
That is a
vote they not be Panchayat election. Sarkar Upon Ga Pachevo, same order of Annexure 3, Collector Balesho. Discrimination Kurchandi.
Discuss before the year, so did not accept the same.
Covered kind order then, oh, each order. Acha. Hey, our case to be say line na. ठीक है जी जो बेरंग रहता नहीं
से challenge करते लेते रहे यार.
बेरा 23.
Item 23.
ये line दे रहा.
এটা non acceptance ତାଙ୍କର challenge এটা non acceptance ତ miss case ମାଇଲା ତାଙ୍କର challenge କରିଥିଲା order
ଓ ଏଟା ଏ line ରେ କରିବା ଆଉ
28 29 30
28 29 30 28 29 30
ମାର
all right.
Item 31. Item 31 your lordship, I will prefer appeal your lordship.
Okay, just 1 minute. On 30 सब वाला.
Item 31.
Yes.
Item 31 I will prefer appeal your lordship.
You will prefer appeal
My lord.
on the premises of availability of statutory appeal and a counsel for the petitioner seeks withdrawal of the writ application in order to pursue appeal remedy. In the event appeal is filed within 2 weeks, delay will be condoned and appeal will be decided on its own merit. And a certified copy of Annexure 2 shall be returned on production of a Xerox copy of this.
Online. Item 32.
May I please, my lord, item 32 on behalf of Mr. S.K. Samudra, my lord, read for tomorrow, my lord.
Tomorrow?
Yes, my
lord. Day after tomorrow.
Oh, bless.
Item 33.
33, my lords, I am on VC.
None appears for the petitioner.
Well, I am appearing for in the VC, my lords.
VC is invisible, Aji.
My lords, let it come tomorrow. I'll.
Kono case kono?
Issuance of a secretariat pass. I have got some I am a lessee in two mines. So for deposit and everything, correspondence, everything, and communications, I need to go to the secretariat. And they have been issuing me for last some number of years. This year, it's pending since more than 1 month. I am facing difficulty.
A name of misuse houni to. I had a Dr. Biswanath Agrawal. Now this is I find again Dr. Biswanath Agrawal, but photo is not matching. You take instruction from he has application at Annexure 6.
My lords.
So you serve 2 copies.
My lords.
I am calling it after 2 weeks.
My lords.
You should notice on the question of admission, matter to be listed in same position after 2 weeks on so and so, Budhwar Karva. In the meantime, 2 extra copies be served on State Council. We will be taking instructions. In the meantime, pendants of the writ application may not stand on the way of the competent authority in taking a decision on Annexure 6, na?
Yes, ma'am. 6.
Annexure 6.
Grateful, ma'am.
Item 34.
ଆପଣଙ୍କର କଣ 10th ସରିଗଲାଣି ମିଷ୍ଟର ମିଶ୍ର?
Lordship?
10th ତ ସରିନି?
I couldn't understand your lordship.
10th day ତ ସରିନି?
No, your lordship.
ନାଇଁ ଆପଣ ଅଛନ୍ତି?
It's not. I'll go back on Sunday, your lordship.
ନାଇଁ ଆମେ ଦେଖିଥିଲୁ ଶରତ ମହାପାତ୍ରଙ୍କର ବି ସେଇ ଇଏ କରୁଥିଲେ ହେଲେ ବି ସେ ଆସୁଥିଲେ କୋଉଠି?
My lordship.
You'll go back.
Lordship.
Right. ठीक. जानना दी. Grandmother, lost grandmother. ସେଠି ଗୋଟେ confusion ହେଲା ସେତେବେଳେ। I had to talk to brother justice.
Lordship.
କିଛି ଲୋକ କହିଲେ ଶାଶୁ ଚଲେଇବେ।
Lordship.
Then I got it confirmed. My mother, she was well, all on a sudden this happened.
Lordship.
All right, yes, 34.
Here, my lord, I am challenging the order passed under section 15B of the Service Settlement Act. Here, my lord, there is no dispute. There is no dispute. One of the brother filed a case to record the land by virtue of a sale deed. Notice was not issued to these two brothers, and the matter was disposed of, and which is not with consonance with the sale deed, my lord.
Well, private parties are there.
Private parties are there, my lord.
Take notice.
My grievance is, my lord, no notice was issued to me.
That's right, but I can consider that only after their appearance.
If they will not have.
And where is the order sheet that no notice was issued?
No, notice was, your lordship will kindly see the page 22. The order. Paragraph 2. This case was registered and notices were issued to the parties concerned. Whether it is made sufficient or they have not appeared, nothing is there, the final order was passed.
Matter is admitted only on the ground that
Admit karantu mo notice
the
karantu.
15B of OSS Act 1958 proceeding has been decided behind the back of the petitioner, who is a necessary party to the proceeding. So notice on the question of admission, fixing short returnable date. It has 6 weeks after the date. Requisites as undertaken by day after tomorrow.
My lord.
Extra copy be served on State Council to appear for opinion of assumption. Yeah.
The lordship has given a date, my lord.
Yes, 6 weeks after date. I am giving a date. Yeah.
May I please, lordship?
Mr. Swami.
Your lordship granted any interim in that?
No, there is no interim application.
No, interim darkar nahi my lord.
My lord, petitioner challenge order dated 35/2023, my lord, passed and under Annex 6, my lord, passed by the Sub-Divisional Magistrate, Mr. Titlagarh, restraining expected order, my restraining me, the petitioner.
What is this order under which proceeding?
Under
144 2 CRPC.
Yes, my lord.
How is civil writ maintainable?
Well, any fundamental right against the ending fundamental right, my lord, the writ is maintainable, my lord.
No, civil writ can be maintainable.
Well,
Criminal writ hai pare.
No.
Criminal writ hai pare. I don't say there is no writ maintainable. It will be a criminal writ. WPC criminal file ho nahi. कौन करिए विड्रॉ करिए
nomenclature change कर लेंगे
ताले application file कले अन्य कोर्ट को जीवो for the nature of impugned order no civil writ will be entertainable. His final and counsel for petitioner seeks time to convert the application. Place this matter after the conversion application comes on board.
Item 36.
Read habo ki mana करनी पहले 482 रे भी read habo
ना सेतो सो रीड थिला रीड मु कर दे
सेटा आउ को बेंच को जीव ना मो पाखे न क्रिमिनल देखि गिरी आसे जो
हां क्रिमिनल दिते है
My submit, my lord.
ये
I am challenging Annex 8, page 51, my lord. This is a notice.
You are challenging or you are seeking direction for disposal of mutation appeal?
No, I am challenging this one because during the pending of mutation appeal, Tahsildar has issued a notice for demarcation and it will be jeopardize my interest, my lord.
What is the harm?
Because I have challenged the mutation appeal. I am having the possession since 1994. The land is
The
in
demarcation is only a paper documentation. It's no handing over of possession.
My lord, indirectly they may take the possession.
So then why don't you file an objection before the demarcation authority that says, sir, there is appeal pending. So you wait.
My lord, sub-collector office is not functioning since January of this year. So no, I am unable to take the lead of the mutation appeal. So otherwise this could not have come.
No, why don't you file application before the Tahsildar? Appeal is pending, there is no dispute.
Yes, my lord.
So if an appeal is pending, some adjudication is pending before it.
Yes, my lord.
So in that event, you can ask the Tahsildar not to proceed in demarcation because it may be prejudicing the appeal proceeding.
Right, my lord.
So withdraw this file objection. I will direct if you file such objection, that will be given a lawful disposal. You are not taking steps there. You are moving High Court for that purpose, which is not permissible. At this submission.
No, we are appearing before this demarcation.
You are appearing before the Tahsildar, but where is your objection to such extent?
Objection, I have not.
So you must file. Petitioner the allegation.
My lord, may I pray that when I will file my objection before Tahsildar, they may consider it.
Yes,
This direction may please.
That's what I am saying. So you withdraw with the liberty to file objection, bring objection before the Tahsildar.
Yes, my lord.
Yes, counsel for having the appropriate remedy of bringing an objection on the points raised herein to the Tahsildar for his consideration in the pending demarcation proceeding. Seeks withdrawal of the writ application, however, with liberty to bring an objection in the demarcation case 39 of 23 in a 79 of 23.
39 of 23, my lord.
39.
Yes, my lord.
39 of 23. Okay, this petition permitted to withdraw, however, with liberty to the petitioner to bring an objection before the Tahsildar in the pending proceeding for his consideration. In such event, the objection, if any, shall be given a lawful disposal before proceeding for demarcation, if any.
Item 37.
Yes, that's 7.
7, my lord, a plot of land was allotted in favor of the person long back in 1989. He was in service then. Now he is retired, very old, suffering, and he is desirous of.
What happened to transfer application?
My lord, transfer application, the form is not being supplied because erroneously.
Then serve copy on Mr.
My lord, I have served on Mr. Mahapatra. And Mr.
Where is
Mahapatra
Mr.
said
Mahapatra?
that. Yes, I have served it, and he has also told me that he will be taking instruction in the next week.
Place this matter on next Wednesday. This court records submission of Sri Das that in the meantime, there is already service of the copy of brief on Sri Mahapatra.
As well as on the vigilance department.
On the?
Vigilance department.
And the council of vigilance department.
Memo is also on the record.
Place this matter on next Wednesday with indication of name of Sri Danand Mahapatra appearing for the Development Authority and Sri Sangram Das.
My lord, the department has taken. You also may say that the standing council.
The council for the vigilance department.
Standing council vigilance.
Yes, in the meantime, take instruction. Form taku de de muko reiterate direction deji. Form de de legality or illegality. After that application comes, you can take a decision.
Amar kol ala double allotment beli kahikiri Taradatta report re pasiwala.
Agya so Taradatta ro judgment padhantu mo to sabu judgment apno publish karleni. Mo gote judgment re clarify karichi je Taradattankar pakhre issue kon thila ଏବଂ ସେ କଣ ମାଡି ଯାଇଛନ୍ତି ତେଣୁ ଏ ବିଷୟ ଗୁଡାକ ତାଙ୍କର ବିଷୟବସ୍ତୁ ନଥିଲା ବୋଲି ମୁଁ ଲେଖି ଦେଇଛି ଜଜମେଣ୍ଟରେ ତେଣୁ ଆପଣ ତାକୁ ଦେଖିକିରି ଟେକ୍ ହେଲ୍ପ ସେ ଜଜମେଣ୍ଟଟା ରିପୋର୍ଟ ହେଇଛି କି ନା ମୁଁ ଜାଣିନି I don't blame you but I also understand how many judgments of mine will be published. I was just checking for my preparation of retirement. Maybe 1100, maybe 450 judgments have been published by now. But I have judgment to my pocket, maybe 2000. So I don't know when all will be published. I don't know. Aji judgment would deji and it's a publishable judgment.
Again.
Principle that decide korichi, publish haba katha. ଦେଖନ୍ତୁ ପ୍ରାୟୋରିଟି ଦିଅନ୍ତୁ ଆଉ ସର୍ଟ ନୋଟ ଦେଲେଣି କି ହେଲାଣି ସର୍ଟ ନୋଟ ରେ କିଛି ଛାଡନ୍ତୁ ଅନ୍ତତଃ ଲୋକ ରେଫରେନ୍ସ ପାଇଯିବେ All right. Next.
Item 38.
May I please, Your Lordship? Here in the case, the petitioner before lordship is a trust and represented. Am I audible, Miller? Oblige you for lordship. The petitioners before lordship is a charitable trust and he is represented by its secretary, who is also petition number 2, Miller. The grievance of the petitioners is that, Miller, the NAC, that is OP number 1, that is Gopalpur NAC, Miller, they have revised the NAC tax, which comprising of holding, Latin and lighting tax, Miller, for 10 folds higher than the original rate.
By 10-fold.
10 folds. Miller.
By 10-fold.
Yes, Miller.
When the last assessment was made.
Miller, last assessment under Annexure 1, 19, Miller, that assessment was made on 26/2/2005, 19, Your Lordship may kindly come, Miller.
2005.
Yes, Miller. That is 26/6/2005 to the extent of 4,000 as a whole for annual, Miller. Your Lordship may kindly appreciate that is the annual, that rate is mentioned. Municipal office to 1/4/2005.
2004 रे सुना केते थिला बे सुना केते अछि भरी
सुनाटा
सेही टर्म रे कन्वर्ट कर दवा
सुना टर्म रे कन्वर्ट कर राज्य अछि जागा टर्म रे करत ने
जागा टर्म तो आउरी केते दूर जाय
जागा टर्म ला किछि नाही
गोपालपुर
that
on
is
sea.
Gopalpur on sea, Miller. Your Lordship must have seen
All right,
that
you
area.
take notice, deposit something.
Miller deposit କରିछि 2 लाख टका just now.
नहीं नहीं 2000 नु
2 लाख टका करिछु.
हां 2 लाख केते टका अछि
Miller,
outstanding.
they are charging under Annexure 8. Your Lordship may kindly come. They are charging under Annexure 7, Miller. They are charging 7,54,000 as area to the extent of 44,400.
आमे जदी भी रीट रे एंटरटेन करबा केते कमिबो कमी 25% दरद कमी.
Miller, मो केस हला
आपण आउ 2 लाख टका दियंतु.
आउ 2 लाख टका आउ लाख टका खन करन चैरिटेबल ट्रस्ट.
2 लाख कोड देइछन 27 दिन परे
last annexure, Your Lordship may kindly see. They have accepted it also, condition on protest, Miller. Your Lordship 31, that is my check, and they have issued the money receipt, annexure 32.
All right. I had issued notice on the question.
That was on 6/6/2000.
Just 1 minute. All right.
My lord.
Issue notice on the question of admission, fixing short returnable days. Counter, if any, be filed within 4 weeks of service of notice. That would liquid the requisites as undertaken by Monday. This case notice as ever, one said. Recording the submission of Sri Das through page 31, there is already deposit of rupees 2 lakhs by the petitioner as against the demand dated 17/3/23 by page 26. This court stays the demand by Annexure 7, subject to, however, petitioner as a further deposit of a sum of rupees 1 lakh.
My lord.
At least within a period of 10 days.
15 days, Your Lordship.
15 days. As undertaken, at least 30,000.
Highly obliged.
The mistake. Yes, order से इटा कौन है ची भूल ही जाई छे हमरो कर दियो डेटा को से हमरो भूल अछि ओके देखी करेक्शन कर थैंक यू